We have a little bit of shuffling to do today, and as you can see, we are changing our process here, that the official agenda for this meeting and future meetings will begin as soon as the briefing session is done and not necessarily at 10 o'clock. So we will need to notify your clients and stuff. If they're thinking they're not going to be or need to be here before 10, they may need to be here early. We also are reordering the items on the agenda. And if you've got your agendas, we've made a lot of changes here. And I just want to go through the numbering system here. So on your agenda, number 1 will be heard 7th. Number 2 will be heard at the end of the meeting. Number 3 will be first, and the hearing examiner ones are going to be next. So 3 is 1, 4 is 2, 5 is 3, 6 is 4, 7 will be heard 5th, 9th will be heard 6th, and 8th will remain 8th. Now, I know someone has a client that needs to catch an early flight. We are aware of that, and we'll make sure to get him out of here before he misses his plane. So, does anybody need clarification on any of those? Okay. All right, I think we're ready to begin. Are you ready, Mr. Mayo?
I'm ready. I'm not positive. I'll need an AV
Okay.
confirmation that my witnesses are ready.
Okay. If there are questions, will you be able to fill in?
Yes.
Mr. Gravy, we see you. Can we just get a quick sound check?
Yes, I hear you. Can you hear me?
Yes.
Okay. Mr. White, I believe you are up first. This is docket number 2024-008, cause number 132-27. In the matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Co. LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280-acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations in sections 3132 2 South 3 West, Duchesne County, Utah. And this was a hearing examiner. Proceed.
Thank you. Gary White, Assistant Attorney General. I acted as the hearing examiner in the proceeding. Madam Chair, would you like my report now, or?
Yes, please.
Okay. The hearing examiner proceeding was conducted in this matter on Wednesday, February 21st, 2024. The proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. No member of the public nor any party opposed the request for agency action. During the proceeding, various sworn declarations and exhibits were admitted into evidence. Additionally, live testimony from hybrid fact and expert witnesses was received. In fact, the witnesses, Mr. Annenson and Mr. Gravy, are here today as well. The Division of Oil, Gas, and Mining and I had an opportunity to cross-examine the witnesses that were presented on behalf of XCL. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and after hearing the live testimony presented at the hearing, I found and recommend the following. First, XCL provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Second, proper notice for the hearing examiner proceedings was also provided. Third, those owners failed to timely participate and should therefore be considered non-consenting parties. Fourth, the proposed JOA that was submitted by XCL includes terms that I found just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. Fifth, the 300% non-consent penalty is fair and justified given the economic and geological conditions present in connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. And finally, XCL met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. After the hearing examiner proceeding, XCL prepared proposed findings of fact, conclusions of law, and an order granting the request for agency action. Both the division and I reviewed that, and after some minimal edits, approved the proposed order. I executed my portion of that proposed order yesterday and filed it with the board's legal assistant. So it should now be ready for the board's review and execution.
Thank you. Division, do you have any?
No, no comment as to the hearing examiner's order.
Or do you have any questions? Okay. Can I just approve it? The matter is approved as presented. Thank you, Mr. White. We will sign the... It's been suggested that we vote on that order here as a board. We have to have a motion. Did someone move to accept it?
Yeah, I would move to accept it. I did watch it on YouTube and appreciated the proceedings, so I'd move that we approve this order.
Second.
All in favor?
Aye.
Opposed? The motion carries. Thank you, Mr. White.
Madam Chair, just one comment. The proposed order, there's one paragraph of that proposed order that was prepared by Mr. Mayo that will allow you to adjust which board members were present and whether the vote was unanimous. So just some minimal edits will be needed.
Okay, thank you. All right. Mr. Mayo, did you have a comment?
My
us a
apologies. I
thumbs
was
up.
trying to sign to council that it can just be done by hand, the edits, but that's my only comment. Thank you.
It's already done. Yeah. All right, I think we're ready to move on to item 2, which is again Mr. White. This is docket number 2024-009, cause number 132-28, in the matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Co. LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1280 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations comprised of sections 29 and 30, 2 South, 3 West, Duchesne County. Mr. White.
Thank you, Madam Chair. Gary White, Assistant Attorney General. Again, I acted as the hearing examiner for this proceeding. That proceeding was conducted on Wednesday, February 21st, 2024. Again, the proceeding was held with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We polled those present and those online to see if any member of the public or any party was opposed to the request for agency action, and there was no opposition. During the proceeding, various sworn declarations and exhibits were admitted into evidence. Additionally, live testimony from hybrid fact and expert witnesses was received. The Division of Oil, Gas, and Mining and I had an opportunity to cross-examine the witnesses that were presented on behalf of XCL. After reviewing the request for agency action, the sworn declarations, and the admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. XCL provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided to all parties. Those parties and non-consenting owners failed to timely participate and should therefore be considered non-consenting parties for purposes of this proceeding. The proposed JOA included terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is both fair and justified, given the economic and geological conditions present in connection with the drilling of the wells. I therefore recommend that the 300% non-consent penalty be imposed as requested by XCL. Finally, XCL met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. As with the other matter, XCL prepared a proposed order, findings of fact, and conclusions of law, which both the division and I have reviewed and received. The division had some suggested edits. Those were made, and I have executed the proposed order and submitted it to the board for its review.
Thank you. Any comments from the division?
No comments based on the hearing examiner's order.
Board, do we have any? Can I get a motion?
I move that we approve the order as presented.
It's been moved and seconded. All in favor?
Aye.
Any opposed? Please note it was unanimous. Thank you, Mr. White.
Thank you.
Hang on just a minute, I write slowly. All right, I think we're moving on to item number 3. Docket number, let's see, Mr. White, are you on this one also?
Yes, but thankfully for your benefit, this is the last one
Yeah.
for me.
My renumbered pages are getting out of order here. Item number 3. This is docket number 2024-010, cause number 132-29. In the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Co., LLC, for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560-acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations comprised of sections 29 and 32, 2 South, 3 West, Duchesne County, Utah. Mr. White.
Thank you, Madam Chair. Gary White, Assistant Attorney General. I acted as the hearing examiner in this proceeding as well. This proceeding was conducted on the same date as the other two, Wednesday, February 21st, 2024. And again, the proceeding was held with an anchor position in the Department of Natural Resources building, Salt Lake City, Utah. No member of the public nor any of the parties opposed this request for agency action. During the proceeding, various sworn declarations and exhibits were admitted into evidence after review of the parties and myself. Additionally, live testimony from Mr. Andenson and Mr. Gravy was again received, and they were admitted as expert witnesses. The Division of Oil, Gas, and Mining and I had an opportunity to cross-examine them as they provided testimony at the hearing. After reviewing the request for agency action, the sworn declarations, and the admitted exhibits, as well as hearing the live testimony presented at the proceeding, I found and recommend the following. Again, XCL provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice was also provided to those same parties for the hearing examiner proceeding itself. Those owners failed to timely participate and should therefore be considered non-consenting parties under the statute and rule. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty requested by XCL is both fair and justified, given the economic and geological conditions present in connection with the drilling of the wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. Finally, XCL again met its burden of proof and otherwise satisfied the legal requirements to compulsory pool the non-consenting parties. As with the other matters, XCL was kind enough to prepare proposed findings of fact, conclusions of law, and an order, And after some input from the division, I executed that and filed it yesterday. And that's my report.
Thank you. Division?
No additional comments.
Board, do you have any questions? Can I get a motion, please?
I move for the adoption of this report.
Second? Second. It's been moved and seconded. Board, do you have, can we, let's vote on that motion. All in favor?
Aye.
Any opposed? Please show that was unanimous, and we will get the order taken care of. Thank you, Mr. White.
Thank you, everyone.
Ms. Garrison, members of the board, with that, I'm done for now. Just to make sure there's, this agenda shuffling, this is set in stone at this point. If I go back to the office, I can come back at a later point for the future hearing.
Yeah, it's just, the timing. We want to make sure we get OVINTIV's witness out in time.
I just want to make sure I know what time, but if the board's okay, may I be dismissed?
Yes.
Thank you.
You may be excused. All right. Ms. Whittier, are you ready?
I am.
We are moving on to item number 4, docket number 2024-011, cause number 132-30, in the matter of the request for agency action of OVINTIV USA, Inc. for an order partially vacating the order entered in the cause number 139-104, and instead pooling interest, including the compulsory pooling of the interests of certain non-consenting owners in the Jurgensen 13-7, 3-1-7-6-5H, 13-7, 3-1-7-6-16H, and the 13-7, 3-1-7-6-46H wells in the lower Green River Wasatch formations comprised of all sections 6 and 7, 3 south, 1 west, Duchesne County, Utah. Ms. Whittier.
Thank you. Madeline Whittier, Assistant Attorney General. I don't often have the privilege of sitting on this side of you all, but this go around I was designated as the hearing examiner in this matter. And Madam Chair, would you like me to roll right into my report?
Yes, please.
Okay. So a hearing examiner proceeding was held in this matter on Wednesday, February 21st, 2024, at the Department of Natural Resources building here in Salt Lake City, Utah. Opportunity for public comment was provided and no members of the public commented. Additionally, no party appeared to oppose the request for agency action, and thus the matter remained unopposed. I received sworn declarations and exhibits into evidence in this matter, as well as testimony from fact and expert witnesses participating virtually. Both the division and myself had the opportunity to cross-examine OVINTIV's witnesses. Upon review of the request for agency action, the sworn declarations submitted, the admitted exhibits, and the testimony provided at the hearing, I found and now recommend the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Those owners failed to timely participate and should therefore be considered non-consenting parties and declared in default. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified, given the economic and geological conditions present in connection with the drilling of these wells, and I therefore recommend the 300% non-consent penalty be imposed as requested. OVINTIV did meet its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties in this matter. Finally, I'll note that OVINTIV prepared the proposed findings of fact, conclusions of law, and order granting the request. The division and myself have reviewed that. I have approved it, and I now present it to you for your review and approval.
Thank you. Division,
No additional comments. No.
Fred, any?
Just in case the board had any questions, Mr. Ellison and Mr. Wall are available to answer questions virtually if needed.
Or do you have any questions about this matter? Mr. Moon?
Just glancing at it, I noticed the weighted average royalty rate is 15 point something, which is, comparatively very low. Just curious. I'm sure it's just an old unit with old wells in, but just any comment about that? Is that why it's so low?
Mr. Ellison, are you available? Do you hear me?
Yes.
Would you answer that question for Mr. Moon, please?
Yes, I'm happy to. Mr. Moon's assumptions are entirely correct. It's just an older area of the basin, so a lot of those leases are 1/8 and 3/16. So that's why it's just lower than kind of the Mighton area, I guess.
Okay, thank you.
Problem.
Go ahead. Are there any other questions? Seeing none, could I get a motion?
I would move that we approve this order or request or hearing examiner recommendation.
Second.
All in favor, please say aye.
Aye.
Any opposed? Please show that was unanimous. Thank you, Ms. Whittier. All right, we're clipping right along here. Item number 5, docket number 2024-012, cause number 132-31. In the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Ute Tribal 13-30, 3-30-31-32-7H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of all sections 31 and 32, 3 South, 3 West, USM, Duchesne County, Utah. Ms. Whittier.
Once again, I'm Madeline Whittier, Assistant Attorney General, designated hearing examiner in this proceeding. And I'll roll right into the report if that's all right with you, Madam Chair. So once again, a hearing examiner proceeding was held for this matter on Wednesday, February 21st, 2024 at the DNR building here in Salt Lake City. Opportunity for public comment was provided and no members of the public commented. Additionally, no party appeared to oppose the request for agency action and thus the matter remained unopposed. I received sworn declarations and exhibits into evidence in this matter, as well as testimony from fact and expert witnesses participating virtually. Both the division and myself had the opportunity to cross-examine OVINTIV's witnesses. Upon review of the request for agency action, the sworn declarations submitted, the admitted exhibits, and the testimony provided at the hearing, I found and now recommend the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Those owners failed to timely participate and should therefore be considered non-consenting parties and declared in default. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geological conditions present in connection with the drilling of those wells, and I therefore recommend the 300% non-consent penalty be imposed as requested. Finally, OVINTIV met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. OVINTIV prepared the proposed findings of fact, conclusions of law, and order here. The division and myself have reviewed and approved that. With one minor change, I now present that to you for review and approval.
Thank you. Division, do you have any comments?
The division has no additional comments.
No comments?
No comments.
Okay. Board, do you have any questions or comments? Seeing none, can I get a motion?
I move for the approval of this report.
And a second? Selma Sierra.
Second.
Thank you, Mr. Borden. All in favor, please say aye.
Aye.
Any opposed? Very good. Please show that was unanimous. Thank you, Ms. Whittier. It is 10 o'clock. We're going to take a short, maybe let's do 10-minute.
Perfect.
We'll reconvene at 10:10.
Okay.
Thank you. We're off the record. We are back on the record. We have had a slight change again in the agenda because the attorney for the next item is not here yet. So we are going to go ahead, and this won't affect, oh, Mitch is here. I thought you'd left. Okay, so we're going to go ahead and move to what was going to be the last of the day, item 9. This is a per acre bonding cost for small mines and exploration. The division will present information about average costs per acre for reclamation, followed by an opportunity for public comment, if there is anyone here. The board will be asked to approve a figure that will be used for bonding small mines and exploration operations. And we're going to start with the division. Please.
Thank you, Madam Chairman and fellow board members. I'd like to introduce myself. My name is Wayne Western. I am the manager for the minerals program, and seated to my right is Kim Coburn, who is our bonding expert. And I do appreciate the opportunity that we have of presenting information to the board and also the public on how we calculate reclamation costs for small mines and exploration projects. So for small mines and exploration projects, there are basically two methods that we have for calculating the bonds. The first one is on a per acre cost, and this is designed to help small mine operators that they don't have to go to the expense of developing a full-scale mine plan and also calculating out the bond. Many of them don't necessarily have the expertise or the money to hire a consultant, as you know, would be anywhere from $30,000 to $40,000 to do that type of work. Or the operators also have the option of seeking a site-specific calculation, and they can prepare it, and then as long as we verify it, then we can go ahead and give them the amount of bond that they have to post. Now, it's important to remember that bonds are not fees. So the operator does get the bond money back once they have completed reclamation. Okay. Now, the board does establish the per acre costs for the reclamation bond. The division does give the presentation, and then we also have the opportunity for the public to comment. We feel that it is important that this is an opportunity for anyone associated with the mining industry to have a voice in how the okay, just doing voice check. Am I better? Okay. Okay, so this gives the public an opportunity to comment on how we calculate bonds. Next. For small mine and reclamation costs, it's divided up into three main areas. The direct cost, which is your earthwork, and then vegetation, and you also have closing of underground openings such as portals, shafts, also drill holes, and any surface facilities that need to be removed. Indirect costs can be a major component of this. There's mob and demob, just getting the equipment to the site. For some small reclamation projects, nearly half of the cost is just having somebody get the equipment to and from the site. Contingencies, this is something that happens. The costs are always more no matter how well you plan, so we just include that in. We do have engineering redesign because sometimes the sites aren't exactly the way that they were shown to be or assumed to be in the mine plan. We have office expenses and project management for staff to cover their fees. And also escalation. These bonds can be anywhere from 1 to 3 to 5 years out in the future. And as we all know, things just are going to cost more in 5 years than they do now. And these are our direct, indirect costs, 10% contingency, 2.5% engineering redesign, 6.8% main office expense, 2.5% project management, for a total of 21.8%. The MOB and DMOB is handled separately because it can be such a large line item. Our main sources of information are the Equipment Watch Blue Book. This is pretty much an industrial standard. Same thing with RS means labor rates. And then we use the Tech Directive 007, which we've been using, the coal program and the minerals program has been using for the past 25 years. And these are our inflation rates. Usually inflation would be, somewhere in the 1 to 3%. Of course, last year it jumped up to 8%, and this year it's, gone down to, not quite 5%. Hopefully in the future it'll get down to 1-2%. And I'll turn the time over to my colleague, Kim Coburn.
Yeah, thank you, Wayne. So our per acre mine amounts are based off of what we call model mines. So we develop different types of mine plans depending on what depending on the size of the mine. We have what we call a mini mine, which are mines up to 2 acres, 5, 10, and 15 acres, along with 20-acre mines. What we do is we use different types of productivity, and we try to use the same different cost sources for those. So the mini mine itself is meant for the weekend warriors, the hobbyers. These are the equipment that you could go rent for Home Depot. So these are limited to be small excavations, such as 10 feet or less, and up to 2 acres maximum. So this is equipment that can be hauled in and out with a pickup truck. Our next type of mine is our 5-acre standard mine, which has an excavator on site. This assumes no leach pads or anything like that. When you get up to 10 acres, you get a dozer on site for our model mines. And 15 acres, you add an articulated haul truck that makes it a little bit more faster for reclamation, because then you don't have to push as far and things like that. And when you get up to 20 acres, you also add in a loader to help that articulated haul truck be more efficient. Each one of these different mines are what we've done in previous years, and we're just updating the cost for that based off of how much costs have increased and decreased over the last year. For our different haul distances, we select the different types of equipment and rentals as well. That way the sites are a little bit more accurate. Depending on where you're at in Utah, as Wayne was describing earlier, we add in different things for MOB, DMOB. And this is just, if you're doing a project here in Salt Lake, you can get there within an hour, but if you're down by Lake Powell, that will take some time to get there. That's usually like the biggest part of some of these projects in remote areas. It's just getting to the site. We utilize pilot cars for some of the larger sites and things like that so we can travel safely. We also have our site-specific calculations that are added. So we have portals and shafts where we work with our AMR team. They do this every day. So we always work with them on getting what the updated costs are that they're seeing out in the field. If there's anything that's unusual, we'll go and get site-specific costs. This is usually buildings and things like that. Those aren't meant for our small mine bound calcs. And they're handled separately. So without further ado, I'm going to move forward into what our costs are on a per acre basis for our reseeding. It's typically $600 when we're waiting on veg, and $2,000 when we're waiting on the seed to take. For mini mines, just on a 1-year basis, so this would be until 2025, it would be $4,400 per acre. A 3-year, or if you think about 2027, that's 5,000, and then 2029 is 5,500. So we're seeing a little bit jump every year, and that's to account for inflation. So operators have the opportunity to lock in their rates so that we don't bother them as often. For our exploration, that is always done on a per year basis. So this is done only until next year. So this would be December of 2025. So that's the 9,500 for the first acre. For our small mines, it would be 10,500. So that goes out for 3 years, or 11,600 for 5 years. So that's 2029. Each additional acre after that is a little bit lower because we assumed we already got to the site. We don't need to already get the equipment there when it's already there for each additional acre. So you'll always see that little jump because that includes getting there to the site. So our 5-year small acre bond costs for 3 years, 37,300, and for a 5-year escalation, that's 41,200. When you get up to 10 acres, this is again when we add in the dozer, so the per acre bond costs increase slightly. But for the 3-year, it's 79,700 and 88,000 for 5 years. So this for a 10-acre small mine, we're projecting out until 2029. That's $88,000 to reclaim it. For a 15-year, again, we're adding another piece of equipment. So the per bond costs increase slightly, but it decreases the amount of time that's out there and increases reclamation efficiency. So our 15-acre goes out to 135,800 for 3 years and 149,500 for 5 years until 2029. Our 20-acre bond costs, so again, this has all the different pieces of equipment working together. It would be 11,000 an acre or 12,000 an acre for 5 years. Or for our 20-acre bond costs would be 202,700 for a 3-year or 22,700 for 5 years. So this decreased slightly from previous years, and that's just mainly due to inflation slowing down. Our general methodology has not changed. Wayne has been doing this for 10 years, and we've been using those same all mines. They're pretty on point for when we go and reclaim the different sites. This has decreased slightly, as I said before, and we recommend that the board approve the costs as presented, where we're not introducing anything different. We're just updating the numbers based off of what everything is currently out there for. And we're just happy to see the decreased amounts, and that'll help some of our operators out. Is there any questions from the board?
Mr. Borden.
2 questions. You had said that surface facilities are generally considered minimal in all these cases?
No, there's generally done on a site-specific basis. So on this case, it's a separate line item. So if you have like a scale house, those are typically pretty minimal, like maybe $1,000 or $2,000 to demolish. But if you have a lot of facilities, so I've had a lot of small mines with portal structures, with mills and other things in there, that's generally a lot more, and we do that on a site-specific basis. So we'll still do the earthwork on our per acre bond cost, but the structures themselves will be done by themselves.
Okay, so that is done on a site-specific
Yes.
basis if there's processing plants and things
Yes,
like
but these costs that you're looking at today are for sites that typically are not there very often. They're for the equipment, they move it, they do campaign mining. So they'll bring all the equipment in, a crusher, a screener, and be there for like a month crushing everything, and then they'll be out in a month, and they'll just have all the material there stockpiled.
And the second question, if you could just refresh my memory, if an operator feels that their disturbance is such that these are overstating the disturbance, the reclamation costs, can they propose, performing a study to demonstrate that those costs might be lower? Or?
Yes, they can request a site-specific bond calculation that they can do, and then the division will review that and then make the determination if it's adequate to ensure reclamation.
Great, thank you.
Do these costs apply to federal lands also?
Yes, there's anytime we issue a permit, you have to have a bond in place. We get concurrence from the BLM and other state agencies before we proceed.
Thank you. Any other questions? Mr. Galecki?
Yeah, a couple, Mr. Western. So this deals primarily with small mines.
Correct.
And what, is it up to 20 acres? Is that what?
Yes, small mines in incorporated areas, 10 acres, can be up to 20 acres in unincorporated areas. Also, for some large mines, the rules do allow us to use the per acre cost if the division feels comfortable with it.
Okay. And then, Ms. Colburn, you mentioned that these rates are based on the current, current values of costs as at RS means and such. And there's also an escalation factor, for each year. I guess, how often is it going to be reviewed, per the per acre thing, per acre costs relative to the escalations?
So to answer your question, it's reviewed on the operator locks in their rates, so they can go 3 or 5 years out. For exploration, it's a year. But they also have the opportunity at any time to go in there and review it. We have a lot of operators that say, I have a lot of operators that locked in their rates for last year, then they saw this year's rates and went, I'm going to lock it in so I get an extra year in. That's fine. They're allowed to modify their plans anytime they want. Just we can't go in there and bother them past that what is already locked in, unless they go out of compliance.
Okay, thank you.
Mr. Church, did you have a question?
Yes, I noticed that on the small mine, you've excluded if they have a leach pad. Is it common, or are there any conditions where a small mine would have a leach pad?
There could be some things like out in the Tintic area that they're doing some test projects where they're using leaching methods just to prove the technology. Because those are uncommon, and usually they would require some type of site-specific calculations. So on there, we might do a per acre cost on the general backfill and grading revegetation, and then we would require site-specific calculations for the heap leaches.
Thank you.
Or do you have any further questions? Mr. Walker?
Yes, does this apply to solution mining processes?
For most of the solution mining, they would be large mines, and we typically don't use these calculations for the large mines.
Board, do you have any? Mr. Borden?
Sorry, that prompted one follow-up question from me. Yeah, let's say you've got a mine that's got less than 20 acres of surface disturbance, but it's an underground mine and it's got a lot of extensive workings underground, but there's no surface subsidence. Would such a mine be covered under the small mine rules, even if it was a very large underground mine?
Yes, that we only regulate the surface area with the exception of the effects of subsidence. So if you had a large underground operation but a minimal surface, we only bond for the surface facilities, and then we take into account any potential for subsidence. But that's the only thing we really do with underground operations.
Thank you.
Board, any further questions? Are we ready to vote on this matter, or do you think we need to deliberate?
Madam Chairman, should we ask if the public has any comments?
Very good. Are there any public comments? Seeing none, would you like to proceed? We ready to approve? Can I get a motion?
I move that we approve the recommended update to per acre bonding costs for small mines and exploration activities.
I'll second that.
All in favor?
Aye.
Aye.
Any opposed? The motion is unanimous. Thank you, Division.
Thank you very much for having us up here and giving the opportunity to do this
Carry on. You're
presentation.
doing a good job. We are now going to return to our previously revised matter. I think we're ready to commence testimony here. This is docket number 2023-027, cause number 132-19, in the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling all interests, pooling all interests of certain non-consenting owners in the Moon 1-12, 4-3-7-8-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of all Section 7 and 8, 4 South, 3 West, USM, Duchesne County, Utah. Yeah. Pursuant to board order, the board will hear oral argument on the matter of the petition for rehearing for reconsideration of the board's findings of fact, conclusions of law, and order entered on November 9, 2023. And Mr. McDonald, would you like to begin?
Let me just disclose that my family has a mineral interest in this drilling unit, and so I'd like to participate, but not vote.
Is that acceptable to both sides?
No objection. I believe that was the case in the hearing, and the original hearing.
Mr. Hunter, you're okay?
Agreed. That was the position in the previous hearing.
Great. Mr. McDonald, would you please proceed?
Yes, Madam Chair. Fred McDonald of Counsel with Lear & Lear on behalf of the petitioner, OVINTIV USA, Inc. With me also is co-counsel Ginger Utley, who will be making the primary argument for the reconsideration by the board. I will then follow up with some matters that were brought up by board's counsel at the inquiry of the board after that.
Thank you.
Thank you. As Fred just mentioned, I'm Ginger Utley of Lear & Lear and appearing here on behalf of petitioner OVINTIV USA, Inc. First, I'd like to thank you all for holding this hearing. It's never a super easy task to approach a tribunal and ask them to reconsider a decision they've made, but that's what we're doing today, so we're grateful that you've granted this hearing and allowed us to do this. We would like to note that all parties have agreed that the record in this case is complete, that the only cases that will be relied upon are the cases cited in OVINTIV's brief, and that the evidence of record is the evidence of record. There will be nothing new introduced into the record. My goal today is to keep this hearing short and simple, as there's only one issue before the board, and that's the imposition of the risk compensation award as set forth in the 132-19 order, wherein the board found that, quote, based on the timing of when the NOP was received by Mr. Reeder and Ms. Eubank, and the fact that the Moon well had already been drilled and was in production when the NOPs were sent, end quote, the board imposed a 150% risk compensation award on all non-consenting owners in the Moon well. In other words, the board based its decision on timing and determined that because the NOPs were sent after the Moon well had begun producing, the risks associated with drilling that well were somehow diminished, and that justified a diminished risk compensation award. I'm sure you've all read the briefs, and they do a good job of outlining the issue and the law, so I don't want to just regurgitate them here. Instead, I want to make a couple of points and then open it up to questions from you all. As I mentioned, there's one issue before the board, but there are two questions underlying that issue that the board should consider in resolving this question. The first is about timing. Is the timing of an NOP's mailing date relevant to the risks incurred in drilling a well? The answer is no. The second question is about proof. Did OVINTIV provide sufficient evidence of risk to support a 300% risk compensation award as it prayed for in its request? The answer to this question is yes. And before I address those questions, I want to remind the board exactly what a risk compensation award is and does. In Utah, we value the recovery of our natural resources, and we have a lot of them. The board's mandate is to promote the recovery of oil. To do that, you have to incentivize people to drill, because drilling is expensive and it's risky. The risk compensation award is part of that scheme to incentivize those operators. And it is exactly what it says it is. It is an award to compensate participating owners for the risks they bear in drilling a well. It's the recognition that consenting parties bear risks when they put their money on the table and say, let's do this, not knowing what will happen either downhole or in the global market. They risk something, non-consenting owners do not. And there's no judgment in that. It's just a recognition that there's two sets of owners who decided on taking two sets of risks, and they should be treated differently. It might sound obvious, but the risks associated with drilling a well are borne chiefly at the time of drilling. Even those that continue into the future or vary are still borne at that time. And importantly, none of them diminish or disappear simply because a well is ultimately successful. With that in mind, let's discuss that first question. Is the timing of when an NOP sent relevant to the determination of a risk compensation award? Another way to ask this question is, Does sending a notice of opportunity to participate after a well begins producing in any way diminish the risks associated with drilling that well? The answer is no. One thing has nothing to do with the other. That's why there is nothing in the governing rules, statutes, or cases that even suggests risk compensation should be tied to or impacted by the date a notice of opportunity is mailed, or whether it's sent after a well has begun producing. As you will all recall, this petition is a continuation of OVINTIV's forest pooling matter that you heard back in July of 23, when OVINTIV sought to compulsory pool several owners in the Moon Well, including James Reeder and Patricia Reeder Eubank. There's no question that Reeder and Eubank received a valid notice of opportunity and had an opportunity to elect, but failed to timely respond. Therefore, they were deemed non-consenting owners in the Moon Well. But throughout this process and following the expiration of their response deadlines, Reeder and Eubank had the guidance of Mike Keller, highly respected oil and gas counsel. Ultimately, with Mr. Keller's assistance, Reeder and Eubank decided to lease to Bro. Because Bro took those leases, subject to Reeder and Eubank's failure to timely respond, OVINTIV sought to compulsory pool Bro and deem it a non-consenting owner. This whole issue arose because Bro then opposed OVINTIV's request for agency action, claiming that because the Moon was, quote, already drilled, completed, and produced by the time the NOPs were sent, unquote, any risk to OVINTIV was illusory and no risk compensation was appropriate. Bro failed to provide any statutory or regulatory support for this argument, which is why the answer to the first question is so easy. There is nothing Bro can cite to support this claim. Instead, it's the Oil and Gas Conservation Act, along with its implementing regulation, that governs. And that act requires the imposition of a risk compensation award of anywhere between 150 and 400% of the non-consenting owner's share of drilling costs, which the act then enumerates as including things like rigging up, drilling, reworking, and the cost of equipment. The act clearly identifies the risks associated with drilling, but is silent with respect to any issues of timing. There's no reference to when a well is drilled, when it begins to produce, or when it pays out in relation to when the notice is sent, because those facts are irrelevant to whether an operator and the other consenting owners have assumed the risks of drilling the well. The cases cited in our petition clearly support our position. Bro does not address them in its opposition or undertake any legal analysis of them. And Mr. McDonald will do some case analysis, but I am going to just give you a high-level view of what happened in Benyon. In that case, the board established, this is a 1991 Utah Supreme Court case, and there the board established a 640-acre drilling unit and located one well on that unit. The location was fixed, and Mr. Benyon was then prohibited from drilling his own well. Over a decade later, the board issued an increased density order that allowed additional wells to be drilled on the unit. Mr. Benyon was given an opportunity to participate in the second well, but he refused. The board then modified the increased density order to detail the costs that Benyon would be required to pay and the revenues he'd be entitled to receive in the second well. That order allowed him to receive a royalty from the time of first production, and it imposed a 175% risk compensation award. And at the time, 200% was the maximum allowed. Benyon appealed to the Supreme Court, which affirmed the 175 risk compensation, and they did not address any issues regarding the timing of when Mr. Benyon was given his opportunity to participate. Instead, the court explained that a risk compensation award, quote, clearly protects the participating parties by compensating them for the risks they assume in drilling the well. And such an allocation of risk and benefits protects non-consenting parties' rights by allowing them to receive revenues from a well for whose drilling costs they are not liable, end quote. Accordingly, the purpose of risk compensation is, quote, to balance the costs, benefits, and risks of drilling a well among the diverse parties. The non-consenting parties avoid any risk, the participating parties assume it, and they should be appropriately rewarded. In short, the timing of when an NOP is sent, whether it's sent after a well begins producing or not, is irrelevant to the proper imposition of a risk compensation award. Considering this as a practical matter, no one is more risk aware than operators. They are constantly considering, planning for, and trying to mitigate risks because their entire financial viability depends on their ability to do so. So if anyone is expert in risk reduction, it's them. Surely, if the date of an NOP's mailing impacted the actual drilling risks in any way, every operator in the state would mail their NOPs only after a well began producing. The truth is that the timing of the NOP's mailing is irrelevant to and cannot factually support the imposition of a 150% risk compensation award. The second question is just as easily answered. Did OVINTIV provide sufficient evidence of risk to support a 300% rather than 150% risk compensation? The answer to this question, as I mentioned, is yes. During that July 26th hearing, OVINTIV presented ample evidence of the risks it bore in drilling the Moon well, both pre and post-spud, to justify its request for 300%. OVINTIV supplemented its written evidence with the expert testimony of Mr. Lair and Mr. Brown, both of whom were qualified as experts and have appeared numerous times before this board. Mr. Lair as a landman and Mr. Brown as a reservoir engineer, a true expert in risk. The risks identified by OVINTIV in testimony and evidence were the potential for mud contamination, higher clay content that might cause the well to collapse, having to sidetrack due to stuck drill pipe, and he mentioned financial risks, how much the well will cost, what the well will produce, and what the price of oil might be over the life of the well. While Mr. Brown testified as to the specific risks associated with drilling the Moon well, Bro presented no evidence regarding the same. Instead, Bro relied solely on the testimony of Mr. Nate Wixom, an expert in petroleum land management, and an exhibit that was deemed largely illustrative, which means it has minimal evidentiary value. Mr. Wixom's only direct testimony regarding risk was his statement that, quote, "Once you make your money back, you have no risk," end quote. This statement highlights Bro's misunderstanding of the law and the error in the 132.19 order. The problem with this reasoning is that it directly conflicts with the Act's plain language and cases applying it, and it's entirely backwards. In the drilling of every well, there is risk. There is an unknown risk and a moment of opportunity to make a choice of whether you will participate. The risk never changes, even if the amount of information you have about that risk does. And that information might give you a benefit, as it did with Reeder and Eubank. This is the backward nature of Bro's argument. It argues that somehow providing owners with their notice of opportunity to participate in the Moon well after it had begun producing was somehow a detriment to them that justified rewarding them with 150%, the lowest risk compensation award ever imposed by this board. But sending the NOPs when OVINTIV did had exactly the opposite effect of what Bro argues. Because the only risks that were diminished as a result of sending those NOPs when they were sent were to the owners who ended up being non-consent. The very owners Bro claims were somehow misled or didn't have sufficient information. They knew or had the chance to know that there was very little, if any, risk in participating in a well that was already producing. There would be no risk of a dry hole, for instance. So they benefited from the notice being sent when it was, because their decision risk diminished, but the actual risks OVINTIV incurred in drilling that well never did. Every time OVINTIV drills a well, it incurs risk. Whether those risks are known, unknown, whether they bear out or never come to pass, actual risks abound. There's a risk of drilling equipment breaking down, collapsed holes, disappointing production numbers. OVINTIV bears these every time it drills. And none of these risks are affected by when a notice of opportunity to participate is sent. Because it's so good at what it does, OVINTIV's been able to successfully navigate most risks most of the time. Because OVINTIV provided sufficient evidence of the risks it faced in drilling the Moon well, this board must determine the risk compensation award based on those risks. And again, none of which include the date the notice of opportunity was sent. Before I conclude, I just want to highlight one policy issue. This board is a policymaking body, and its policies should promote development and encourage operators to do the same. To achieve that, operators must be able to rely on the board for fair, consistent application of the governing rules and laws. The 13219 order is an outlier. It does not do either of the things mentioned, and it is not factually supported by the record. We would like to ask the board to take administrative notice of all compulsory pooling orders entered in the last 3 years. And in conclusion, I would like to turn the rest of my argument time over to Mr. McDonald to address some of the issues raised by board counsel yesterday.
Thank you, Ms. Utley and board members. Just to follow up one other argument that Ms. Utley made here, you do have to realize that the notice of opportunity to participate allows the party to participate at 100% of their share of cost. That's the same opportunity they had whether the drill was before the well was drilled. So they even have a better opportunity after a well is drilled to make that election. And in this case, Mr. Reeder and Ms. Eubank did not do that, even with the advice of recognized expert Utah Oil and Gas Council. Therefore, Bro took it. So it's important to remember that that notice of opportunity to participate allows them to participate for their 100% share of costs, which is the same result if that notice had gone out ahead of the drilling. Now, yesterday, the board's counsel advised us some questions that the board may had concerning the Bennion case and the risk that's imposed on a well-by-well basis, which I will address. That's really not relevant to this particular matter before you today, but I think it's more for educational purposes going forward. The second question was regarding a footnote in one of the cases that we cited, the Sam Oil case. First of all, to note that it's a footnote, so it's dicta from the Utah Supreme Court. But secondly, it raises some questions about should the timing, as was said, the notice of opportunity, if it wasn't given before the time of drilling, should that be relevant? So I'm going to address that first, and then I'll get to the Bennion case, because this one is a little more relevant to the matter before you. This Michigan case was a 1986 Michigan case, and it's easily distinguishable from any of the facts involved here in the Utah statutory and regulatory process. In Michigan, well, what the situation was there, they said that they were not going to impose a non-consent penalty because the party was not given the opportunity to participate before the drilling of the well. But you have to understand why that was the case in Michigan. First and foremost in that case, Michigan does not have a specific statutory provision addressing the amount of risk compensation to be awarded. At that time, the court recognized that there was no statutory provision addressing how and what amount they should apply. What there was a statutory requirement was, and also in Michigan, they sought spacing and pooling at the same time. So again, remember in Utah that spacing establishes people's correlative rights. In this case here before you with the Moon well, the spacing had already been entered, so we knew what the correlative rights of Mr. Eubank and Mr. Eubank and Ms. Reeder, or no, other way around, Mr. Reeder and Ms. Eubank were at that time, okay? So the issue in the case was also a question of what was the size of the unit and then what was going to be done. And here's the most important part. I want to read the statute that was applicable at the time. Excuse me, hang on a second. The Michigan statute at the time said this: such pooling order shall authorize one of the owners within the affected unit to drill the well thereon and provide that the well shall be commenced within 90 days of the pooling order, or the pooling order shall be null and void as to all parties in interest. Okay? So then what happens then, that means that they can't drill the well until the pooling and spacing order is put into place. So then the situation there is, within that 90 days period, a party has the opportunity to either pay the AFE amount and agree to participate, or they can await the outcome of the drilling, and if completed as a producer, that's when they're going to impose a risk assessment award. And what happened here was that was never done under that statutory process. They had drilled the well before the pooling and spacing order had been put in place. So they said because they didn't follow that statutory procedure, that's why they agreed that they weren't going to impose a non-consent penalty, because they hadn't followed the procedure. Here, that is not the case. In Utah, we have a statute and a regulatory process that provides a notice of opportunity to participate. You come in at 100% if you want to participate at that, and then you have a time period. And after that time period, if you don't do it, then you're deemed non-consent. That's the distinguishing factor here with that Michigan case. It really is distinguishable and should not be applied, and in fact, the Supreme Court didn't apply that case. It's a mere footnote, and it's in dicta. Now, the second part of this was the question about Benny, and how does this going forward on a well-by-well basis kick in? And I'm going to read you the language from the Benny case that the Supreme Court said. Moreover, upon close examination, it is evident that the legislature intended that the statutory non-consent penalty be determined on a well-by-well basis. The language of the statute is still the same. That stipulates that the board is to determine an amount not less than 150%, now to or not to exceed 400%, of the costs and expenses, blah, 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 in the well, as Ms. Utley stated. The non-consent penalty is therefore to be determined by the risks associated with each particular well. That can only be done if the board has the power, so on, to deal with that. Now, that's recognized. We don't argue that each election that has to be made by a party is on a well-by-well basis. You can't say because you are in the first well and you declined that you're non-consent for all the other wells. There still has to be a notice of opportunity to participate in an election made on each and every well. Now, to expedite things and to deal with that, the statute was changed and the board approved regulations to prevent having to do, for example, 40 compulsory poolings for each well that's drilled within a drilling unit. That process allows, again, the election and notice of opportunity to participate has to be sent out by the operator every well. But in the case where there's already been a compulsory pooling order entered, they state and give the information provided in an affidavit and the original pooling order to state that you have 30 days in which to object to this, and if you do, then it comes in front of the board, and the board can deal with that. If the party is willing to go with 300% in an original pooling order, then they've given the opportunity to challenge that, but if they don't, then that's going to be adopted by the board and going forward. That also makes sense in the context of joint operating agreements that are voluntarily entered into. If you enter into a joint operating agreement and it provides for a 300% non-consent penalty, that applies to every well drilled under that joint operating agreement. So it's a consistent policy, but it also provides due process to any party who wants to challenge what the risks are and the imposition of the risk assessment penalty at the time of that well. They have their due process, they're given that opportunity. That's what our system is set up. So it recognizes it in full compliance with Bennion. But again, I want to emphasize that's for your education purposes going forward. In this case, the Moon well was the only well drilled, and that's what you're in front of you as far as what we're asking for the petition for rehearing. Thank you very much for your attention, and we'll reserve time to rebut.
Thank you. Mr. Hunter, could you introduce yourself for the record, please, and proceed?
Sure. Anthony Hunter for Bro Energy.
Please proceed.
Thank you. I'm going to try to maybe take this in a little backwards order so we can have what's fresh in our mind, and then I'll try to refresh everybody's memory as we go farther back in time. Hold on to your hats. I'm going to agree with Mr. McDonald. He and I conferred just before this, and I think we see eye to eye. The Bennion case, I think, is pretty good guide and principle still. The recently adopted regulatory changes does, in fact, require new notice every time a subsequent well is drilled. And that is a new opportunity for someone to come in and challenge whatever needs to be challenged. As far as the precedential effect, there's none. of setting a risk assessment penalty or a non-consent penalty award. We'll get to that terminology a little later. But it's not a precedent, but it's a factual record that can be relied upon. The board can take administrative notice of the risk factors that were presented in the original hearing, and the operator can allege or support by affidavit that those risks were present or are present in these new wells, and the board can take that sworn testimony in the prior hearing under advisement and go with it or not. But if no one challenges it, the board has no reason to disturb its prior factual findings. So a risk assessment penalty on the first well doesn't necessarily apply to all the rest of the wells, but it could, unless someone comes forward to say, no, the world is different now. We have new facts that need to be brought to light. So I think that Mr. McDonald and I are in agreement that while it's not precedent, it's reliable factual record that the board can point to support its new decision to impose a risk penalty on subsequent wells. So I think that simplifies things for everyone concerned, as long as that, the difference, of course, being it's not as a matter of law that risk penalty amount is correct. It's that as a matter of established fact, unless disturbed in a new hearing, that's the appropriate penalty. And I think that would that would insulate the board from challenges and streamline processes quite a bit. And with that, I think we're done agreeing with each other. Walking backwards, starting with that Traverse case out of Michigan, a couple things that need to be pointed out. The Michigan statute itself was extremely not explicit. The Michigan statute just said that pooling orders need to be just and reasonable. That's it. And the board's equivalent in Michigan adopted regulations that said, for example, what Mr. McDonald said about the 90-day limit. But they also went a little bit further. And this is the crux of their regulatory situation. Only if a party elects to await the outcome of a well are they eligible for a non-consent penalty. Or on the flip side, the operator is eligible for a risk compensation award. And I'm going to break all this down for everyone. There's two sides to this. There's an award that an operator becomes eligible for if they check all the appropriate regulatory boxes, which then imposes a penalty on the non-consenting parties that funds that award. So call it whatever you like, but it's two sides of the same coin. If the operator wants to be eligible for the award, they've got to apply for it and demonstrate that they meet the criteria. The burden of proof is on the operator to show that they are eligible for it. If a non-consenting operator wants to avoid the penalty, their only job is to show that they don't qualify, the operator doesn't qualify for an award. If the boxes aren't checked, they don't get the award. If you don't come in first place, you don't get the blue ribbon. It's as simple as that. So every time, whenever you heard Ms. Utley say a number of times, and I'll discuss this a little bit further too, but Bro didn't prove, Bro didn't do this, Bro didn't carry its burden. Bro doesn't have a burden. The burden is on the operator to show that they've checked the boxes. Bro's job is to show that there are some boxes that were not checked. And Bro did that, but we'll talk about that in a little bit. But back to the Traverse case. The language in the Michigan regulation that was created by your analog states that it has to be a choice from the non-operator. The non-operator has to elect not to participate. They have to await the outcome of a well. If they don't know what's going on, there's no election and there's no waiting. It's just a surprise that comes in the mailbox that says, by the way, a well's been drilled, pay us what we demand, or we'll just take triple. Surprise. There's no choice. There's no waiting. And that's why the Michigan regulation, adopted by your analog, makes it clear that it has to happen prior to. You have to have a meaningful opportunity to make that choice and to start that waiting. Because, as the Michigan regulation also points out, the risk of a dry hole is what really the risk compensation award or the non-consent penalty is about. It's about waiting to see if the other guy makes just made a mistake when he chose to drill this. Oops, there's no oil there. Waiting on the sidelines is about whether or not oil is found, not how hard it is to bring up. That's an engineering problem, not how expensive or inexpensive oil is at any particular time. That's a global problem. It's, is there actually oil underneath that ground? That's what a risk compensation award is for. That's what a non-consent penalty is supposed to incentivize against. Don't sit on the sidelines wondering if they're going to strike pay dirt. Get in there with your cash and help them out. All that other stuff, that's engineering problems. Those are problems that the world all over faces. It has nothing to do with, and this is the key part, this particular well. Because as Mr. McDonald and I both agree, risk analysis, risk compensation, non-consent penalties is on a well-by-well basis. You have to look at the situation, the geography, the geology, the engineering problems of that well. So under the Michigan arrangement, it's got to be an election and it's got to be in advance. In Utah, that's how it used to be. The statute in 2015 required that notice was given in advance. That statute was changed. In advance was taken out. Substituted in was notice according to the board's rules. Now, that doesn't mean it can't be in advance. It just means that it's up to you guys to decide whether or not timing has anything to do with it. It's in your hands. And you've kind of already done that, a little bit. The definition of an AFE is a good faith estimate of costs to be incurred, future tense. Necessarily implying that this is something that is a guess because we don't know yet. Technically speaking, any AFE that goes out after the well has been drilled is no longer an AFE. It's a billing statement. And the recent changes to the reg says you got to send an AFE, which is defined in the reg. It doesn't say a billing statement will do. Now, it seems like a ticky-tack little argument, but it gets at the heart of what made the Michigan case work. And it gets at the very fundamental fairness. Mr. McDonald pointed out that spacing and pooling happens at the same time in Michigan. Happens that way in North Dakota too, pretty much. But that's because everyone is already ready to go. In Utah, it's basically at the discretion of the operator as to when they want to pool. There may be good business reasons for it. There may be practical reasons for it to put a lot of time between the spacing and the pooling. That's how the industry has worked here. I don't expect that to stop and turn on a dime. But I think it's clear that under other states' arrangements, pooling has to happen before drilling. You got to know who's in and who's out. And if, for practical reasons, for business considerations, that isn't possible, well, okay. It's just that you don't get the non-consent penalty for it because you never gave anybody else a chance. The operator assumed the risk for its own business purposes or whatever. That's fine. But you can't penalize anybody else for it because they never had the chance to await the outcome. They never elected to await that outcome. And again, I just want to remind you that that was the regulatory scheme that your Michigan analog structured, and the Supreme Court, or the Court of Appeals in Michigan, was okay with that. The analog here in Utah, the statute was changed, in advance was taken out, but our board rules currently kind of keep it in. In my view, they keep it in because you can't have an AFE if you actually know what the costs were. And there's another reminder in this case, OVINTIV did know what the costs were, and those costs exceeded the AFE. And they sent out a notice of opportunity to participate. That was wrong. The AFE no longer had a good faith estimate. It had a knowingly lowball number. And that's why I'm going to switch over to Ms. Utley's argument on her timing. That's the timing issue. In this particular case, as things stand right now, the way the industry operates, notices of opportunity to participate come in after the well has been completed, producing, and in our case, according to my expert's view, already paid out. That's the timing problem. And that alone justifies the board's imposition of the minimum possible risk compensation award or non-consent penalty, however you want to define it. Because you can't incentivize companies to send out misleading, knowingly wrong information. That's an incentive. Send out lowball NOPs, lowball AFEs, and then smack somebody with a much higher bill that the operator already knows is wrong. Send out an NOP for $5 million, send them a bill for $7 million, or your proportionate share thereof, which in this case we didn't know, but you know, the board decided against me on that. I guess I'll just have to live with it. But the Michigan and the case, that's how it should be done. The spacing and pooling need to be closer together in time and prior to drilling. And even if the pooling order can't be done before the drilling, the NOPs need to go out before the drilling if the operator wants to qualify for the non-consent penalty. Finally, I did want to point out one last thing in the Sam Oil case, that footnote 4. I love footnotes, as I'm sure anybody that's ever read a brief of mine knows. But that the cite in there says this, the footnote says this: it is doubtful that a penalty assessment could meet constitutional standards of due process when the penalized party was not given an opportunity to participate in the drilling. As Mr. McDonald correctly points out, that's dicta. That's just advisory language that the court wants to send out. That's advice. That's a wink and a nod to everybody who's reading this that this is the way the wind blows here. And what the Supreme Court cites there as its support in that footnote is a treatise by Professor Kramer. And I've been citing Professor Kramer in my stuff since the whole time I've been here. And he definitely agrees with me that the risks of drilling a well are drilling, the cost of drilling, the mechanical risk that you take of engineering and geological problems happening, and the risks of a marginal well. That's it. And the statute in Utah compensates you at a minimum of 150% for the risks of drilling, 150% for the risks of mechanical failure, and the minimum, that 150, is for that marginal production. In that order. And I think there's another quote in Bennion that I want to read because it kind of demonstrates that also as well, not just in the footnote, but in the body of the case itself. My computer went to sleep, sorry. Inherent in the drilling of any well is a risk of mechanical problems, price fluctuations, or insufficient production to cover costs. Those same three factors I just mentioned. For this reason, the legislature has decided that a minimum non-consent penalty of 150% is justified in all cases. It is left to the board to decide in each case whether the risks of a particular well warrant the minimum penalty of 150% or the maximum, which at that time was 200. It's in your hands. And the Supreme Court gave you those three factors: mechanical problems, price fluctuations, meaning the price of sand, oil, fuel, drilling rig costs, whatever, and insufficient production to cover costs, a marginal well. The answers are all right here, and they all point to you guys being absolutely justified in imposing the minimum 150% penalty in this case. And I'll yield to Mr. McDonald.
Petitioner, would you like to rebut that?
I think we both have some comments to make about Mr. Hunter's presentation. Firstly, that Travers case that he spent the majority of the time discussing is absolutely irrelevant in a posit, and this board can't rely on it. The Utah Supreme Court cited that case in a footnote and said, hey, Sam Oil, thanks for citing this case. Doesn't apply, and moved on. That case was a 40-year-old case from a state that has entirely different oil and gas development from Utah. if this board follows Travers, what it's saying is we're ignoring the Utah Supreme Court that said don't follow Travers, and we're going to follow Michigan. So I don't think that there's any basis to give any credence to those arguments as they're set forth in that case.
Thank you. I'm going to address a couple other things. Mr. Hunter cited the Bennion case for the concept that you must be given the notice of opportunity to participate for drilling. The key here is the notice of opportunity to participate. And in this case, the notice of opportunity to participate was the same whether it was before drilling or after. You have a choice to either join in and participate in the well or don't. They were given that opportunity, meeting constitutional standards. That's what the Bennion court was trying to address. Was there appropriate notice of opportunity to participate so that the party had its rights to protect its correlative rights? The other factor here is statute here in Utah also specifically says that the board can adopt a joint operating agreement that's signed by other parties in the drilling unit. Here, there was several, the record reflects there are several parties who signed joint operating agreements with a 300% non-consent penalty. And that applies for all wells through the drilling unit. So it's not just a factor that, that you go to the minimum 150%. You had testimony from both a landman who is qualified as an expert in petroleum land management, and more importantly, an expert in reservoir and petroleum engineering who testified to the risks as to this specific well. All the boxes, contrary to Mr. Hunter's suggestions, were checked off. And again, this is a situation where you had a party who had competent oil and gas counsel, knows the rules and statutes that are in place today, and they did not comply, and therefore they were non-consent. They had the opportunity to participate. They already had the knowledge that this was a producing well. They could still participate. Now, let's go to the AFEs for a minute. AFEs are a good faith estimate. And when you sign an AFE under a joint operating agreement, you're bound to pay whatever your share of cost is. You are agreeing to participate. If you think those costs are unfair, you can come in and challenge those costs in front of the board, because one of your statutory mandates in a pooling order is to determine if the actual costs are fair and reasonable. The AFE is intended to give you the opportunity to make the election to participate, and when you do so, and Bro is a competent oil and gas operator or party here that knows this as well as anybody, you are making the election and you are agreeing to pay your share, whatever they are, subject to challenges if you feel they're unjust and unreasonably charged. And that's where the risks come in. Why do you think there are cost overruns? Because you get stuck. You have to go fish to get the tool out. I mean, there's a whole bunch of things with it. You need to understand that in that context. With that, we'll close our argument. Thank you.
Thank you. Mr. Hunter?
Just 2 quick points I just want to address. I'm going to join the Mike Keller fan club. I think I've been a member for a while. He is an excellent attorney, and I've worked with him a couple of times. But he wasn't here to testify, and to impute knowledge of whatever onto him or his clients is not allowed. So when the OVINTIV says they knew or should have known, there's no should have known here. The burden is on OVINTIV to check the boxes. So imputing knowledge to Mr. Keller or his clients about whether something was risky or whether it was not, that's not appropriate. And in fact, if I recall correctly, the information that came in via OVINTIV's testimony was that Mr. Keller did not get the information he wanted, specifically the revenue, the numbers. So he didn't feel like he had enough information to evaluate the risk. Now, whether or not that's true or not, that's hearsay, but that was the information that came in. And I think the board should discount that and not think about it at all, because number one, it's not relevant. It's OVINTIV's burden to prove things, and number two, it's hearsay. So, but that's just my comment on that. The other part is I just want to clarify that BRO and its officers and employees have operated wells in the past, so they're well familiar with both sides of the ball here. So when I'm here making these arguments, it's not because they're strictly one-sided. We are on one side in this case, but they know the other side of this. And this is their position, and they would expect to be treated this way if they were in OVINTIV shoes. And that'll be all the information, all the comment I have on that. Thanks.
Thank you. Division, do you have?
Thank you. Just a few quick thoughts. The division isn't taking a position in this matter. As we said in our original briefing, this is a discretionary decision for the board based on the factual evidence that is presented and your interpretation of what those risks are in that particular well. It is completely up to your discretion to determine what the appropriate amount is that is imposed. I believe that under Utah law, as long as evidence supports that determination and it's not arbitrary or capricious, your determination should stand. A few things that I would like to clarify. I do think under the statute it is clear that the burden is on the operator to come in and present evidence justifying a risk compensation award. However, it's also mandatory. If you find that those non-consenting owners are non-consenting, you are required to impose a risk compensation award. So under the statute, it is not an option to impose less than that 150%. I think that the parties have adequately stated that this is a factual determination, so it does not have precedential value on future wells, other than to perhaps suggest what has been done in other wells in the same unit. This risk compensation award just applies to this well and won't affect any others. My last thought is only that it, to some degree, given the circumstances in this case, there was a lot of argument below about the notice that was provided, whether it was sufficient, whether there was misrepresentations or not. To some degree, it almost seems to come down to the question of whether this penalty is, or this award, this risk compensation award, is a penalty against the owners, or is it an award to the operators for taking the risk? Because if it is an award to the operators for being willing to take the risk of all of the geological problems or drilling costs that might come up, then it probably should, in my opinion, not depend on when the notice is given. That those facts would exist irrespective of when that notice is given. However, if it is a penalty against these non-consenting owners who are choosing not to participate, and it's penalizing them for doing that, I think that the circumstances and facts surrounding the notice do become more relevant. And again, that is something that is within the board's purview, and that is your public policy determination. All we have now is the rule that says the specific geological factors that the board considers, but it does say also that you can consider other factors that you deem important. And I don't have anything else. Thank you.
Thank you. Does the division have any further comments? Okay. Board, do you have questions? Mr. Church?
Yes, I would like a clarification from Ms. Utley. When we are talking about assessing risk on a well-by-well basis, I think I heard you say earlier that risk never changes. Even with increased information, are you saying the absence or presence of risk, or are you saying the degree of risk with additional information?
I'm sorry, Mr. Church, can you just repeat that one more time?
Okay. I understood, and I may have misheard you, is that you indicated risk never changes, even with increased information. So the risk doesn't go away when you drill a well, but does the degree of risk change? I just wanted a clarification or your view on that. When there is additional information, if we're looking at a well-by-well basis, does additional information lessen the degree of risk? when you say risk never changes, is that the degree of risk or risk?
What I meant by risk never changes, if that is what I said, and I assume it is that there is always risk. There is always risk in drilling any well. You don't know when an operator is about to drill what they might encounter, but there is some risk. Your question about the well-by-well basis and whether that risk can decrease with information, I think yes. As operators learn more, gather more data, gather more information, I think those risks can lessen, and those are factual determinations that would have to be made at that time.
Okay, thank you.
When you send out an after-the-fact NOP, do you tell the people that there is a producing well on the property?
I believe the requirement, I can't speak to that, that's a factual question for the witnesses, but I believe the regulation states that you have to put information about when the date was spud, and I believe if you look at the record, it does show when the well was spud.
Thank you. Board, Mr. Moon.
Yeah, a question for Mr. McDonald, because he's been around this longer than any of us, other than Mr. Rogers back there, possibly.
Gray Hay gave it away, right?
So, as we are all aware, 300% has kind of been the standard risk compensation award. I think most of us are aware that that's higher than most of our neighboring states. 200%, 175, 150 is more the standard. Could you just give us kind of the history of why we ended up at 300 and why that's, in your opinion, why that's kind of maintained for this long, given the fact that drilling wells is pretty much down to a science here in Utah, where wells are paying out pretty quickly. Getting to the 300% is another question. I'm sure there's some that have. We're not seeing those in our, respacings. We're not seeing those, but kind of give us a little history and help us kind of understand why we started it. We've been at 300 for so long and hoping that we hold to that.
Well, again, this is strictly opinion, okay, or from my perspective and representing operators for as long and non-operators as well. It started with 300% because it's kind of a weighed factor of what's involved. I mean, again, sometimes joint operating agreements will be complete wildcats, which justify, I've seen it even up to 400 or 500% in joint operating agreements when it's an exploratory area, okay? I think the 300% in the Uinta Basin, again, it started out that we had the vertical wells and we went up to 4 wells in the vertical wells, but then the new technology came with horizontal wells, fracking, and all of that. And so I think it's been a general agreement, and you'll find this from most of the operators that operate there, both as an operator and a non-operator, that they have agreed that 300% is a fair risk compensation award for them to do this. Now, when you get to that and you say, well, now the technology is such and such, in most cases, the operators then say, well, of course I'm going to participate because I think this has a great opportunity to be a success. And therefore, if you decide not to go, then they believe that 300% is an appropriate compensation for the people who do agree to go ahead and drill that. And again, as you've heard, there's all kinds of different risks that are involved in these horizontal wells. The sticking, and the claying, the collapsing. As you're getting close to other wells that have already been drilled, there's the opportunity for depletion, which could affect it as well. So I think that's the general idea of where it came from, maybe a lower amount initially, as to it starts out as an exploratory thing, and in particular, in this case, and in the Uinta Basin with the horizontal well drilling, that's the justification that the operators, both as operators and non-operators, have agreed is an appropriate amount to compensate for a non-consent.
Yeah, but operator between operator, there's a give and a take all the time. They participate in each other's wells. Is that really indicative of the risk the actual risk that needs compensated for at this point in time? That's the question that goes through my mind.
Well, and again,
Because it's an award, if it's between operators, give and take, depending on which well they're in or out of. But for the non-consenting party, I don't know if that always, if that risk really, or if that justification completely justifies it.
well, again, if they don't want to be part of an oil and gas operation, they have the opportunity to lease as well. That's the notice of opportunity to participate. It's a notice of opportunity to participate to lease or participate as a working interest owner. So they also have that situation there where they may not have to do that. But again, all I can say is that when you have industry agreeing on a standard, it's something the board needs to consider. And out there, again, 300% is generally agreed upon. And you have not seen any of the board or any of the operators come forward asking for 400%, because the board has made it very clear that that has to be the ultimate risky wildcat well out there before they would even consider that.
Tony, did you have anything on that question?
Thank you, Mr. Moon. Yes. Your observation is a good one, that there's a big difference between payout and 300%. A lot of wells pay out and then never actually reach 300%. So when you impose a 300% penalty, that is in effect permanently removing that property interest from the non-operator. As a practical matter, it's just not going to come back. So in the context of a royalty owner, that may not make a difference in the long haul. Because the weighted average royalty comes in. But in the context of another working interest owner, a non-operator, that's a complete and utter loss of your investment. Even if you're willing to pay your fair share and try to really hard and come before the board asking for the opportunity to do it, it's gone and may be gone forever at that 300% level. So yeah, that's an important observation. Second thing I want to point out is on the it's getting down to a science. I think you said, Mr. Moon. Yeah, drilling a dry hole out there these days is mostly unheard of. It just, is it going to make the money back fast, or is it going to make the money back not as fast as you'd like? And that goes back to OVINTIV's testimony at the hearing, that their biggest risk that they considered is the price of oil over 30 years. That was their testimony. I confirmed it on cross, but it was brought out on direct. So in their calculation, when they asked for the 300%, and when the parties contract for that 300% penalty out there, that's the risk they have in mind. We're going to build an asset, we're going to put a hole in the ground and hope it, makes its money back in a reasonable amount of time. They're worried about oil price fluctuations. That's reasonable in a contract situation, and it's reasonable for an operator to think like that. But that's not compensable under the statute. Oil price fluctuations are not compensable under the statute as a risk. And if they testified that that's their biggest risk and that's the one that's on their mind, and it's, oh gosh, that's what we're really worried about, that does not support a 300% risk penalty. All those other risks exist, absolutely. Mechanical risks, engineering risks, a marginal production, those still exist, and that's why the 150% minimum is there. But it doesn't justify going higher than that. If that's their biggest concern, it's not a justification. And just as my last point, to follow up on that, contract is not regulation. You've got two policies in this board: prevent waste, protect your relative rights. You're not in business. You're not in the position to evaluate risk between parties and that kind of stuff. That's between parties is between parties. And so protecting relative rights and preventing waste, those are your guide stars. And if the statute doesn't support compensating for oil price fluctuations, then you can't impose it.
Could I ask just for clarification? The landowners, non-consenting landowners, are receiving their weighted royalty.
Correct.
During the payout period. Bro is a lessor.
Correct.
For two individuals. So they are getting their weighted landowner royalty. Is Bro receiving any compensation during the penalty, or would you receive any compensation during the penalty period?
Zero.
Okay. All right, Mr. Gordon.
Thank you. I actually wanted to follow up with something Mr. Moon had asked about. Again, it's about the 300 risk reward. This is a thought experiment. Bear with me. I'd love to hear actually from all of you about this. Let's say a hypothetical new greenfields basin, very little drilling. You're going in, you're bearing the full geologic risk because you haven't proven out the stratigraphy, the stress field, special hazards to the mechanical aspects of drilling, et cetera. So a regulatory body might go, oh, a 300% penalty sounds reasonable. Let's say as that basin is drilled more and more and the geologic risks are better defined, so those uncertainties are more controlled, we should get better estimates of what the risk is. The risk profile actually is better defined. That means you can probably better define costs of drilling and things like that. Is it at some point appropriate for that regulatory body to start imposing lower risk penalties, 250%, because overall the uncertainties are declining as the basin becomes more mature in its production?
I'm not going to disagree with you on that, but again, the statute says you do it on a well-by-well basis. And in this particular case, this is the first horizontal well that was drilled in this drilling unit, and you had, information provided to you about area around there and why it was appropriate from the standpoint of OVINTIV's expert witness in petroleum engineering that it's still justified at 300% non-consent. But again, if this drilling unit, you're in the 12th well that has been authorized for it, I would imagine the board would consider at that point, where do you draw the line that it's no longer a risk that's worthy of 300%, depending on what the testimony that is before you on that particular well.
And I may have misspoken about a basin-wide. Basin-wide is a consideration, but also what's going on locally within a portion of that basin.
Right.
Yeah. Anybody else?
Mr. Moon.
If I could follow up with Mr. Borden's hypothetical, yeah, and I would even say that if you really are a wildcat, as Mr. McDonald pointed out, maybe a 400% penalty is justified for the first well. If it's truly a wildcat, yeah. But then the next well's in that basin, in the unit next door, a mile away, well, maybe that one's only a 300 because there was a discovery. So it's not really a wildcat area anymore. And then once you get drilling units all around it, and this is just the next drilling unit over in an area that's got dozens of drilling units, well, it's not really a risk of a dry hole anymore, which is traditionally the Traverse case in Michigan, the Kramer treatise. The big risk is a dry hole. Everything else is less than that. Those are smaller risks. And once you've eliminated those dry hole risks, the bigger penalties really aren't justified. You can agree via contract with other people that that's going to be the penalty. That's fine. But as Mr. Church pointed out, an increased knowledge decreases risk. Yeah. Once you've proven up the stratigraphy, it's not as risky as it used to be.
Vision, do you have any comment on that hypothetical?
Maybe not so much on the hypothetical. As I've been thinking about some of the questions, I think one important thing to keep in mind is the procedural posture of most of these compulsory pooling cases that result in these pooling orders. The vast majority of cases in Utah are not contested. And so they come before the board on a default and the order is entered and the relief requested is basically granted. So I think a lot of the, that we have this history of 300%, some of it may be given to the fact that this is not something that is considered in every single case outside of the parties have defaulted and we're entering the order. I think if the board does have thoughts on the things that should be being considered, the division does its best to ensure that the operators are meeting the requirements of the code and raising situations where we feel like that hasn't been met. Where this is discretionary, typically to the board, if the division does not want to step into the shoes of parties that have not been bothered to show up. But if there is direction that we can be given to ensure that things are being met to the standards that the board would like, that direction would be very helpful.
Mr. Moon?
We're trying to figure that out, so we'll, we figure it out. Question for Tony. So, the argument is persuasive that, really if you're going to be a joint owner in a well, you ought to have notice up front and all of that. And to be penalized, it makes sense. Let me know what my opportunity is before you, penalize me down the road. But help me understand how me as a mineral owner is actually harmed by getting a notice of opportunity to participate later, when there is more information publicly available, and some you can maybe get from the operator, from surrounding wells. How am I harmed as a mineral owner by a late NOP?
Of course. So there's some intricate moving parts that are going on here. There's two classes of non-participating owners, right? There's a mineral owner, as Mr. Moon is, who is he owns minerals, and heaven knows how he got them, and that's part of the issue here, is that there's probates that aren't closed and all other kind of stuff, but he owns the minerals. Then there's working interest owners, people that have leased from those mineral owners. But the NOP covers the entire class of people who are basically not the operator. All right, so the regulation, the statute has to treat everybody in that group fairly and the same. However, there's a difference between a landowner and a non-working interest, a working interest owner. The statute lets the royalty owner receive a weighted average royalty payment during the time of the payout. So in reality, someone in Mr. Moon's shoes doesn't really care. And more importantly, doesn't care what the AFE costs are. Because if he's not going to participate, he doesn't care how much the well costs. He's just going to get a check in his mailbox. But the working interest owner cares very much, because not only is he going to, and what happened in this case, still be responsible for part of the royalty payment, but also he has to recoup his investment in buying the lease in the first place, paying a bonus to somebody like Mr. Moon, generating commerce for landowners, right? That's what the purpose of non-operator working interest owners are. Stimulating competition for leases, giving people better terms, maybe, giving people better royalty amounts, maybe. That's why you want that competition, so that it's not just a take it or leave it lease from every operator that's out there because they're the big guy. You want that competition. The landowners want that competition. And if the landowners want to see that competition, well, the working interest owners have to be treated the same as the royalty owners, even though the royalty owners don't have that incentive to care about what the AFE is.
Madam Chair, can I respond to that? Yes. Pro Energy is taking leases, is an oil and gas operator. They should know when they take a lease from a party, what is the status of AFEs? Did you receive any notice of opportunity to participate? It was incumbent on them to ask those questions. They didn't. They took it subject to the Reader and Eubank non-consents. The time had already passed. If Mr. Keller wanted to ask for extension of time, he could have done that. The record does not reflect that. And I'm not trying to impose what Mr. Keller may not have known or not, but the regulations on oil and gas, when you receive a notice of opportunity to participate, are out there, and he's an oil and gas lawyer. Thank you.
Any further board comments? Mr. Church?
Just a question for division. So the statute grants the board discretionary decision-making between the degree of a risk assessment on, or what can be awarded, risk award. Is that based then, discretionary to be based on factual evidence per each well? And if not, if it's a general discretionary thing that should be defensible, is that something that divisions experts could sit down and come up with a formula on wells to lay out what category of percentage that should be?
Let me make sure I understand your question.
Rambling question.
No, you're good. So it seems like first you were wondering what the statute states, and then second, whether or not that award was based on each specific factual circumstances of the well, or whether it was a more general award. And then third, whether or not the division felt like it could, come up with some sort of, table or something, or a set of guidelines that could speak to that. To answer your first question, so did I get that right? Sorry.
Yes.
Okay. To answer your first question, the statute just says that each pooling order shall have an amount to be determined by the board, but not less than 150%, nor greater than 400% of the non-consenting owner's share of the costs, and then it goes through certain costs. So it doesn't really give you much information about what that is. It just says that you have the discretion to determine what that amount is. The rule that's been passed goes further and suggests that the board can consider the geological and engineering uncertainties and difficulties in drilling the well, the availability of information from prior and current drilling and development in the area, and the unique specified costs of the well. So, but it says those are just some of the factors, that the board can consider other factors as well. So I guess that's what the law says to consider. I think the Benyon case is pretty clear that the risk compensation award is per well. It should be based upon the specific circumstances of that particular well and the notice of opportunity that was sent on that particular well. And I think council, for the most part, agrees with me there. As to whether or not the division could formulate some sort of table or something to help, I probably am not the best person to ask that question. I can ask my client and go back, or we have the deputy director here if you'd like to hear from him, whether he thinks that's a possibility.
I think that's a question for future discussion.
Okay.
Sierra.
For the division, real quick, I don't know if I missed it in your description. When the statute says that the board consider these different factors, is it shall consider, which is a must, or can, which we can dismiss or not?
Okay, so the statute says that you shall impose an award, but it doesn't specify what factors you consider. It just says you shall impose it if they're non-consenting. The rule says that you may consider among other factors. So it is discretionary.
Mr. Hunter.
Just a point of clarification, and I want to get Liz's opinion on this. The shall consider is, or shall impose, is the minimum penalty, and Mr. McDonald, I think, alluded to that as well. The board doesn't have a choice on whether to impose a penalty. You can do it within a range, but you have to do it. But the factors, but the things that are compensable under that statute are these things. It's not a expandable list. That was my point about oil price fluctuations earlier. There's a list that has to do with drilling and completion. Am I recalling that correctly?
Yes, I mean, the statute, and I maybe could see if I could put it up on the screen if it would be helpful to look at. The statute says that an amount to be determined by the board basically shall include the non-consenting owner's share of the cost of staking the location, well site preparation, rights-of-way rigging up. As I interpret that, it is defining the parameters of the amount that is being awarded. It is these specific costs that you are increasing. in my opinion, I don't read that necessarily as defining the limits of what the board can consider. I read that as defining the limits of what the board can award.
And in fact, if I can jump in here, in the Benyon case, the court explicitly said in the quote read by Mr. Hunter earlier, inherent in the drilling of any well is a risk of mechanical problems, price fluctuations, or insufficient production to cover costs. So price fluctuations are considerable and have been considered by the court. In addition, Mr. Brown's testimony wasn't only about the costs associated with the well. He did provide evidence of geologic risk and engineering risk. So even if you ignore his statement about financial, which you don't have to because price fluctuations can be considered, there was still plenty of adequate evidence of risk, the same kinds of risk this board has accepted as supporting a 300% risk compensation award in the past. And I would just like to take 1 second to respond to Mr. Hunter's kind of constant calling OVINTIV names, that they mislead, that they hide the ball, that they, I think I counted 6 times in his opposition of those kinds of phrases that I just think I would like to make a note on the record are not supported and not helpful. And the last point I'd like to make is that I'm a little confused about how Mr. Hunter has standing to even make these arguments, since he did not become a record owner until after the expiration period expired.
And also to make those arguments on behalf of the parties who did not show up.
Thank you. Yes.
At the hearing.
I'd like to take the opportunity to address those comments, if I could.
Mr. Hunter.
First of all, the price fluctuations quote that I read the whole quote, not just the price fluctuations part. And the reason that the whole quote is important is because price fluctuations taken in isolation, prices of what? It doesn't say what price. You have to read the whole quote to figure that out. And because they cited the Kramer treatise in the footnote, and as I've already pointed out, Kramer's big on those 3. It's the dry hole, it's the mechanical failures, it's the marginal well. You've got those 3 right there. The Supreme Court was reading Kramer when they wrote that. And so price fluctuations are actually more like cost fluctuations or price of materials, just like in the statute that Ms. Harris read out, right? It's the staking. It's the materials, it's the drilling, it's the prices you pay for those things. Those fluctuate, and they do. That's the risk that the Supreme Court's talking about there. And then to Mr. McDonald's point, we have standing because we're a party. We're qualified as a party under the regulation. We responded to the notice. The board asked for briefing and argument, so I'm here to answer questions and make arguments. That's why I'm here. Thanks.
Do we have any further questions? I have just kind of I don't even know quite how to ask it. Companies choose to drill a well, hoping you get 100% consensus in your well. Is there kind of an upper limit of, if we can't get the last 5% or 1%, that you'll go ahead anyway? I mean, there are things, and how do you, should you be compensated ahead of time in decisions made anticipating that there might be mechanical I mean, you're not going to know that before. I just am concerned.
I would agree with that. And as far as if there's a limit within the company that says if we've got 99.9% ownership that's either leased or participating, we may elect to carry that. And that in that case, it would be treated under common law co-tenancy principles, which they would get 100%. They don't get anything until 100% payout, but then they account for it after that. But they make that on a business decision as to whether it's worth it to come in front of you and expend the cost for a compulsory pooling. But that's an individual company decision on that. And as far as, again, the risks each time that they drill, it depends on the circumstances with that. And there's always risks involved with these things. Like I said, you may have a well and you may drill a well right next to it, but that one all of a sudden has fishing problems, or you know, there's mechanical difficulties, or the driller messed up, or I mean, there's even close wells like that. There's always risks involved with it, and that needs to be compensated for.
Thank you. Board, do you have any further questions? Mr. Moon.
So, Tony, assuming we want to, back up our 150%, give us our best arguments, defensible arguments, as concisely as you can, to back up that 150%. And there's kind of two parts to it. That can we defensively consider the fact that the well was already drilled, and the fact that did those risks go down? Can we even consider that at all, or were all those risks fixed before the well was drilled? That's one question. And then the other one is specific to this well. What factual things do we have to say that this risk compensation award is appropriate, given that in general we've been doing 300%?
Thank you. I think you all have been asking the questions that give you the answers. I'll try to work my way down here, and I'll finish with you. Mr. Borden brought up the idea that, well, as we learn more, the difference between, as a hypothetical, as we learn more about a basin or an area or a unit, the knowledge goes up and the risks go down. And so, while, as Ms. Harris pointed out, that if you get a default situation where no one contests it, 300% is probably fine because the parties involved have deemed it that way, and no one's here to challenge that. So, even though the basin itself may be well explored, the parties think this is what is necessary, and if no one protests it, then maybe that's okay. But that's where you start off. And we'll move down to Mr. Church. Yeah, knowledge decreases risk. And what you didn't hear from OVINTIV in the hearing was that we were afraid this was going to be a dry hole, because they knew it wasn't going to be. And that's traditionally the biggest risk of oil and gas drilling. And that's what the risk compensation penalty is there to address. You take these costs, multiply them by whatever multiplier you decide, based on the risks. That's how you do it. And then Ms. Garrison identified the holdout problem, right? The non-consent penalty versus the risk compensation award, two sides of the same coin. You don't want to incentivize people to hold out. You want them to jump in if they're going to jump in. And so, yeah, there's a threshold. At some point, you're going to just either carry those people or force pool them. So, yeah, that determination is made prior to drilling. At what level of participation are we going to go? At what level of participation are we going to assume the risks, whether we're going to carry them or whether we're going to do a non-consent penalty in a pooling situation, right? OVINTIV made those decisions well prior to drilling, but no one else got the opportunity to make those decisions. So the timing here that's where the timing comes in. Who should we elect to wait, like the Michigan case said? I mean, in order to be penalized, it's a penalty on the non-operator side, it's an award to the operator. If we're going to be penalized, we need to be noticed about that. And I think Ms. Harris had it right when she said, if it's an award, well, maybe we should let this go. But if it's a penalty, maybe we should be a little more strict about checking the boxes. It's both. It's both at the same time. It's an award to an operator, it's a penalty to a non-operator. So those decisions were made prior to drilling, whether or not the participation factor justified taking those risks on their own. And then down to Mr. Moon, the timing, as I mentioned in my brief, doesn't really matter. I can justify the language you used on the timing by saying that the NOP, the AFE contained in the NOP, apologies, contained an incorrect number, which was...
How far was that off? Sorry to interrupt.
My recollection was 10%. All right, it overspent by 10%. It's in my brief. It's in one of the footnotes. But they knew at the time. And Mr. McDonald, I see leaning forward, he's going to tell you that 10% is pretty standard. It sure is. Exceeding an AFE by 10% is pretty standard. That's correct. When you exceed the estimate, that's standard. When you have actual knowledge that the number is bigger, that's not. That's the difference. And that's why I keep using words like misleading, because OVINTIV had actual knowledge and they put on their NOPs that the number was smaller. And if you're in the position of a working interest owner trying to evaluate the risk, the difference between a $100,000 JIB bill and the difference between a $110,000 JIB bill could be material depending on the size of your operations and your budget. That's pretty material. And you may not be done. As Mr. McDonald points out, there may be additional mechanical problems down the road. You have to anticipate that the well is going to be more expensive than that as time goes on. So, and is the board going to make 10% the number? I mean, you're asking the division if maybe they can make a table for you to determine the risk compensation decisions. Do you want a table for how much exceeding AFEs are going to be appropriate to? You can, if you'd like. That's well within your remit under the statute. We can do that. But the question of timing, I can justify the language by saying the number was wrong. But in reality, you don't need it. And again, this is in my response to the petition for rehearing. The board has ultimate discretion on this. It's pretty much undisturbable. As long as there's substantial competent evidence on the record, and I think I've given it to you, pointing it out, the fact that their risk calculation big number was oil prices, and that's not compensable under the statute, as well as the incorrect information on the NOP, that's all you really need. And the Supreme Court is not going to disturb that. Trust me, I know. I brought something to them a few years ago, and they told me, nice try. But if there's substantial competent evidence on the record, we're done here.
Madam Chair, can I respond to that? Yes. Okay, there's a couple factors here. First of all, the regulation talks about sending an AFE. You send the same AFE that was sent to everybody else because that's the risk that they take at that time, okay? Number two, Bro never challenged the reasonableness of the actual costs that were incurred that were provided in the testimony and exhibits. So when he says about that, oh, you know, that would have made a big difference, it didn't make a difference. There was no challenge to the reasonableness of the costs. And that goes back to the point about what an AFE is. It's a good faith estimate, and you're bound to pay your share of the costs, whatever they may be. And if there's an overrun, you agree to pay for that. And if you think that overrun was inappropriate, then you challenge it, and Bro didn't do that. Okay? Also, he brought up the substantial evidence. As in our brief, we outlined to you Mr. Lear's testimony at the most challenges Mr. Wixom's testimony. And Mr. Wixom's testimony was fairly thin on that. But even if you weigh those two out, you have the testimony of Mr. Brown, who was the petroleum engineer who has the risks, that's uncontroverted. It's uncontroverted. So if you're worried about going up to the Supreme Court and substantial evidence, what is your substantial evidence here? It's substantial in favor of what OVINTIV provided, thereby also checking off all the boxes that Mr. Hunter keeps talking about.
Well, I would agree that it was demonstrated there is risk. Question is, how much and what should the award be?
And again, Mr. Brown's expert testimony was, and Mr. Lear's expert testimony was, that 300% was justified under these circumstances.
Just, if I may, just a brief comment on legal standard. The Supreme Court on Appeal does not reweigh evidence. That's the board's purview. And it's however the pebbles line up on the scales, that's your job. Once you make a decision, the Supreme Court's not going to challenge this board's particular technical expertise or legislative grant of authority. And it explicitly leaves the number, the 150 to 400%, in your hands. There is no wiggle room on there at all. It's yours.
So I think one last question. So Tony, how do we justify the fact that the standard's 300, In standard requests, we have this same list of risks, and in this case, we have that same list of risks, and we went 150 versus 300.
You didn't. And this goes back to the default question. Every time you get a default pooling request up here, no one challenges anything. Whatever the company decides in agreement with the other companies was risky and worth compensating, you guys just go along with because it seems like everybody's okay with that. But when you hear evidence, when you're required to put those pebbles on the scales back and forth, which is your legislative grant of authority, then everything opens up. And then you have to take a look. And then you have to look at Exhibit GG and see that there's only mechanical risk on there. There's not a risk listed of a marginal well, and there's not a risk listed of drilling a dry hole. You didn't hear evidence of the two biggest risks that typically justify a risk compensation award or a non-consent penalty. The evidence you did hear was that their biggest risk was price fluctuations. Operating a well, which is not compensable. There's a line in the statute that says 100% of operating costs. You don't get extra money because you're taking on the risk of operating a well. That's your job as an operator. That's the risk you assume when you enter that business. So the statute puts it in your hands, uncontrovertibly. And weighing of evidence, that's your job, uncontrovertibly. And as long as there's anything in the record to support your decision, it's your decision.
Thank you. Board, any further questions? Back to you, Mr. McDonald. Do you have any follow-up?
No, I don't think so.
I would just point out that based on what Mr. Hunter just said, the question is then why is he complaining about the AFE amount? Thank you.
Thank you. Mr. Hunter, do you have any further comments?
Just that I'm trying to help the board justify the timing language. You don't need it if you don't want it, but the AFE amount is important on the timing. That's all.
Division, do you have any closing comments?
No, I think the only question I would have is, since there were questions about the language of the statute and the rule, if council would have no objection, I'm happy to get copies of those that you can look at during your deliberations, if that would be helpful. But again, I don't want to provide something that they have not seen.
I think our council has that information. Thank you. Okay, I think we are going to have to deliberate on this, and it is lunchtime. So I think, oh, Mitch. Oh, sure. Huh? Right, right. We don't usually have public comment, but is there someone in the audience who would like to speak? We need him. Please introduce yourself and.
Josh Sigler with XCL Resources. As an operator in the basin, one of the things I heard commented on is kind of the level of risk that operators still encounter as we're drilling in this basin. Obviously, we've gone into a development mode and are drilling more and more wells in the basin every day. But that comes with drilling multiple benches, multiple new benches. I think just this year we'll test 3 new targets. I also, if you look at just the area, the horizontals are being drilled routinely in the basin now. That's not even just routinely, but single horizontals to test area has expanded by, depending on how you want to draw your lines, 30 to 50,000 acres. So there is still and so this is not to take absolutely just this single instance into account. I'll let those facts speak for itself. But the idea that the basin, it is maturing. But as it matures, we're also finding that there's more to do, and there's still lots of risk on the table. I'm not out and out qualified with you guys as a factual expert on engineering, but as someone who is deeply involved in the drilling and completions of wells, that mechanical risk is more substantial in many of these unconventional systems and formations that we drill today than just that dry hole risk. And that mechanical risk does lead a lot to the enhanced possibility of the marginal well. So maybe the dry hole isn't as high, but I'd maybe argue that operators take a bigger risk, particularly in these large horizontal developments, at the marginal well coming in than they ever have. So particularly with the amount of capital we outlay into a development. So there is still substantial risk, and I would hazard against thinking that we've knocked that out of the park at this point in the development of the Uinta Basin. Thank you.
If I could comment as well. Also with XCL Resources, I'm Mark Gravy, EVP Reservoir and Development. In my opinion, a 150% penalty would more or less be a free ride into a wellbore. It takes about a year for us to spud a well to actually begin producing hydrocarbons, and then it takes a considerable amount of time to then recoup your investment as well. The cost of capital is pretty expensive. Debt rate have gone up. Equity is hard to raise. So in my opinion, if you could invest in a well and just wait for it to pay out and then back in as a partner, that would be a pretty good opportunity at 150%. So you would be encouraging people to non-consent AFEs and then get a profitable stream after not investing in the wellbore, really burdening the operator of the well and limiting the growth of the basin, in my opinion.
Thank you for the public comment, but we want it understood as public information and has no evidentiary weight in the decision here. With that,
I have one thing that I think Liz, this is Kevin Anderson from XCL, I'm online.
I think we're done with public comment. Appreciate it, but I think we're going to close it out here. Thank you. Do we have any further comments from the board? Okay. I think we are going to recess, do a little deliberation, have lunch. Will 45 minutes be sufficient? Who is here that has airline flights? And what time do you need to be? I guess the question is, do you need to go next or after lunch at 1? Okay, and is that XCL or OVINTIV? Both. Both. Well, I guess it doesn't matter. All right. 45 minutes be good for everybody? Okay, we'll be back at 1, reconvene with the next issue, which will be OVINTIV. We have OVINTIV next and then XCL. Good afternoon, ladies and gentlemen. We're here to finalize this last issue, and I believe we have a motion.
Yes, based on a review of the overall risk profile of the Moon 1-12, 4-3-7-8-7H well, and as established by the factual record, I move that the board affirm the 150% risk compensation amount.
It's been moved and seconded. Can I have a vote? All in favor?
Aye.
Any opposed?
I abstain.
We have, 5 affirmatives and 1 abstention. Mr. Moon is abstaining. 6. Sorry, 6 affirmative, 1 abstention. I'd like to direct the board council to prepare the order within the next 30 days, please. And I think this matter is now concluded. We're going to move on. Let me find my... Okay, are we set up for the OVINTIV matter, or, okay. Get on the right track here. We're going to move on to the next docket item now, which is docket number 2024-013, cause number 132-32. In the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Beale, Utah 13-34, 4-3-4-9-1H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all sections 4 and 9, 4 South, 3 West, USM, Duchesne County, Utah. Now we have appearance of, or swearing in of witnesses or appearances of witnesses and counsel.
And before that, I just need to disclose that I am a very, very small working interest owner in this well. So I will be participating but not voting.
Do we have anyone that needs to be sworn in?
I believe so.
Are there any objections to Mr. Moon's participating?
No objections.
Okay.
No, none from OVINTIV.
Okay, thank you. Did you say we had some witnesses that need to be sworn in?
I believe all the witnesses need to be sworn in, yes.
Where are we here? Appearance of counsel, where are we?
Yeah.
Yeah. Appearance of counsel.
Ginger Utley of Lear & Lear on behalf of petitioner OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Any objections? Please proceed, Ms. Utley.
Thank you. With me today are OVINTIV's witnesses, Peter Burns, Senior Land Negotiator, and appearing electronically is Christopher Wall, Senior Reservoir Engineer. Could we have the witnesses sworn in at this time?
Raise your right hand, please. You want both at the same time? Okay. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you. The resumes of Mr. Burns and Wall were submitted as Exhibit A. If separately asked, Mr. Burns and Wall would verify the contents of their resumes are true and correct. Mr. Burns has been recognized as an expert in petroleum land management in prior causes, most recently in December 2023 in cause 132-26. He will provide factual and expert testimony. Mr. Wall has also recently appeared and was qualified as an expert in petroleum engineering in cause 132-31 last week on February 21st, 2024. Presuming the division has no objection, I ask the board to recognize Mr. Burns as an expert in the field of petroleum land management and Mr. Wall as an expert in the field of petroleum engineering.
Are there any objections?
No objections by the division.
Please proceed.
As is standard practice, I will be moving for admission of my exhibits at the end of my presentation. This cause requests the compulsory pooling of the drilling unit established for the Lower Green River Wasatch production comprised of the entirety of Sections 4 and 9, Township 4 South, Range 3 West in Duchesne County, what I'll refer to as the subject unit. The subject unit was established by board order entered on February 23, 2018 in Cause 139-150. A true and correct copy of the 139-150 order was submitted as Petitioner's Exhibit B. Pertinent to this hearing, the 139-150 order expressly authorizes the drilling and completion of long lateral horizontal wells, such as the subject well at issue in this cause. There's a single well within Section 4 that was previously drilled and operated by JMD. That existing well is orphaned and has been in shut-in status since September of 2016. According to the 139-150 order, as of the first day of production of the first long lateral horizontal well drilled upon the drilling unit, the previous sectional drilling unit comprised of Section 4 for vertical or directionally drilled wells and short lateral horizontal wells converts to the drilling unit, and production from the sole existing well is thereafter to be allocated on a drilling unit basis instead of a sectional basis. As a consequence, allocation of production from the subject well is on the drilling unit basis as of its date of first production of August 3, 2018, while the aforementioned conversion occurred on an allocation of production from the existing well, if and once it again begins to produce, will be on a drilling unit basis as of September 1, 2018. In accordance with the 139-150 order and APDs approved by the Division and BIA, OVINTIV spud the subject well on March 24, 2018, with the date of first production of August 3, 2018. Several owners of undivided oil and gas interests in the subject unit and subject well have refused or failed to lease or otherwise agree to pay their proportionate share of the well costs, including the names that appear on pages 2 through 3 of the request. This is a big list. And so in the interest of brevity, rather than reading each owner's name, I would refer the board to testimonial exhibit number 1, which we filed on Monday of this week, for a complete list of the parties to be pooled. There are a couple of changes I need to make to that exhibit as well. We got some updates last night, and I will address all of those changes in just one moment. This request seeks the pooling of dozens of owners and estates. It's a significant pleading and seems a bit intimidating with so many names and exhibits. But other than the sheer volume of owners, this is a straightforward compulsory pooling, like any other. There's nothing the board hasn't seen before, and we're hopeful that we're able to make this request easily digestible in smaller chunks as we go. Each of the owners received mailed notice of the RAA at their last known address of record, where an address was available, and none have objected to the pooling or otherwise responded to the request. On February 20th, 2024, proof of these mailings was filed separately in this cause as Petitioner's Exhibit MM. Because this is such a large list, there are several updates of which I need to make you aware. The following owners have since leased to OVINTIV, and 2 of these owners still appear on the exhibit we filed on Monday, so you can cross those out for your own reference if you would like. Brett Eugene Wilcox and Bart Wilcox both appear on your exhibit, but should be removed as they have leased. Similarly, Kelly Glazer, Lloyd Nielsen, Natalie Davis, and Patricia France and Tim Shepard have also all leased. Additionally, we removed 3 trusts from the original request for agency action: the Marital Trust, the Paula Christine Callister Trust, and the Richard Kazier Callister Trust. Richard Callister, the administrator and trustee of the estate, has provided affidavit evidence that the trusts don't own an interest in the subject lands, and therefore we removed those trusts.
Could I request that you give us a revised testimonial exhibit when you file it?
Yes,
Thank you.
absolutely, I'll do that.
Sorry for the interruption.
Oh, no problem. In addition, some of the fee leases were granted by parties claiming by, through, and under the estates of certain deceased parties. Those estates are identified on pages 3 through 5 of the request, and for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to the heirs or devisees. As such, there's the possibility of some unknown party claiming through those estates who is unleased and not pooled. And I will refer to these as the unknowns. Again, rather than reading this long list of estates, I would just refer the board to pages 3 through 5 for the complete list of estates to be pooled. Pursuant to order of the board entered on January 17th, 2024, in this cause, a notice of opportunity to participate naming each of the unknowns was published in the Uinta Basin Standard for 2 consecutive weeks. Proof of that publication was filed separately in this cause as petitioner's exhibit FFF. No party responded to that notice or otherwise tendered his or her share of costs of the subject well. OVINTIV therefore seeks to have these unknown parties pooled and declared as non-consenting owners. As to the non-consenting parties, OVINTIV seeks the following: imposition of the 300% risk compensation award, imposition of the terms of a JOA materially the same as signed by other working interest owners in the drilling unit, and which terms have been previously deemed just and reasonable by the board in other compulsory pooling hearings. And during the recoupment period, the unleased non-consenting owners will be entitled to an 18.356514% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of spud, or March 24th, 2018. Bro Energy and International Petroleum are lessees under fee leases within the subject drilling unit. Bro and IP both elected to participate but did not execute a JOA. As such, they're being pooled solely for imposition of the JOA, and the interest of their lessors must also be pooled, and their lessors will be entitled to the royalty provided in their respective leases. Similarly, JMD is a lessee under fee leases within the drilling unit and has not yet made an election or signed a JOA. As such, both JMD and the interest of its lessors must be pooled, and JMD's lessors will also be entitled to the royalty provided in their respective leases. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and implementing regulations. In addition to the published notice of opportunity to participate in the Uinta Basin Standard that I mentioned previously, notice of the filing of the request and this hearing was also duly published in the Uinta Basin Standard on February 7th, the Deseret News on February 2nd, and Salt Lake Tribune on February 4th, all of 2024. The division filed a response in this cause on February 2nd, 2024, expressing no opposition to granting the request. No other objections or responses to the RAA were timely filed. As none of the alleged non-consenting parties filed a timely response to the request, pursuant to Utah Administrative Code R641-104-150 and R641-108-400, we move to enter an order of default against them. Thank you. With that, I will begin the examination of my witnesses. Peter, will you please state your name and business address for the record?
Yes, Peter Burns, and OVINTIV's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your position with OVINTIV?
I'm a senior land negotiator with responsibility over this drilling unit, among others.
Can you please provide the corporate and bonding status for OVINTIV?
OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to New Fuel Production Company and by merger of OVINTIV Production, Inc.
Thank you. During your testimony, you will be testifying about exhibits C, D, E, triple D, triple E, triple I, G through I, and testimonial exhibit 1. Have you reviewed these exhibits?
Yes.
Were they prepared by you or OVINTIV personnel with your review and input?
Yes.
Great. Let's start with those exhibit C. Can you please, can you please describe what exhibit C shows?
Yes, Exhibit C is a regional locator map showing the subject unit outlined in red. It's within the town limits of Bridgeland, and Highway 40 cuts through across across the middle of the subject unit. This is sections 4 and 9, Township 4 South, Range 3 West, in Duchesne County, Utah.
Thank you. Oh, sorry. Oh, this is touchy. That's what I'm trying. I apologize. I think there's one more page of it. There we go. Exhibit D, can you please describe what this exhibit shows?
Yes, this first page of Exhibit D shows the drilling unit and the plat of the mineral ownership within that unit. The light green is tribal trust minerals, the darker green is allotted minerals, and the yellow is fee. This drilling unit is comprised of 1,288.75 net gross acres divided into 25 tracts. Tract 1 is tribally owned. Tracts 8, 23, and 24 are allotted lands managed by the BIA. Tracts 11 and 25 are owned by UDOT, administered by the Utah Division of Forestry, Fire, State Lands, and the remaining tracts are owned in fee. The Beal well, shown on the prior page, was drilled on the far east side of the subject unit. It was spud on March 24th, 2018, and began producing on August 3rd, 2018, as outlined in the RAA.
Thank you. That is also track description. Mr. Burns, would you like to address at this point the reason for the delay between the well being drilled in 2018 and this pooling action being brought now 6 years later?
Yes, so under the old pooling rules, when this well was drilled, a pooling order would have given a wellbore only pooling, and now under the new rules, it is a it's a unit pooling with a well by well election. And so under the original pooling, that was not a cost efficient method for Newfield at the time. We've also since undergone a change in ownership. Newfield was acquired by Encana, now OVINTIV, and so we have set out to try to give all of these owners an opportunity to participate. So in June 2020, when the new force pooling rules changed, made it far more economic to pool these parties since it's based on a unit pooling as opposed to just the wellbores. This change in the pooling rules allowed for more certainty, a 30-day firm election, which also allowed for OVINTIV to have a firm working interest to plan for its future capital outlays for future infill drilling. Lastly, today's hearing really on this Beal well is really a culmination of a roughly 1 year's process of work, updating title, reviewing airship, to ensure that we've given a notice of opportunity to participate to all of the potential owners. As Ms. Utley mentioned, there's a ton of airship in this subject unit, so it has taken many, many months to get to this point, to understand who we needed to give notice to, but also ensuring that they did receive that notice.
Thank you. Moving on to Exhibit E. There is a correction we need to make to this total compulsory pooled interest shown on Exhibit E. Mr. Burns, can you please describe what this exhibit shows and explain the correction?
Yes, so this is the Beal DSU working interest summary. As it shows, OVINTIV is the majority working interest owner in this DSU and operates the subject well. A total of 7.0057% will be pooled, and we can provide an updated exhibit after the hearing to show that revised number. And that revision is due to the new leases that we just received and those owners being removed from the hearing. So the additional lessee working interest owners in this DSU, there are a number of them: Forex Resources, Platform Energy 4, Kaiser Francis Oil Company, Moon Ranch LLC, Finley Resources, Inc., Snowbird Acquisition, Otter Creek, PEC Exploration, the Petrum Group, Bro Energy, and International Petroleum LLC. All except for Bro and International Petroleum and JMD have signed JOAs with OVINTIV, the terms of which contractually govern well elections, including the elections made on the subject well. OVINTIV has recorded a pooling declaration pooling all existing leases pursuant to the authorization contained in the various pooling clauses of the leases. And we've also secured an approved communitization agreement pooling these leases with the tribal leases.
Thank you. And as Mr. Byrd mentioned, we will file a corrected Exhibit E that reflects that updated information.
Can I interrupt right there? Glenwood Joseph Purdy is one of my neighbors. I didn't hear you mention him coming off this list. He is leased.
Yes, he is leased.
Okay, so he'll come off this.
Okay, I will add
just
that
make sure.
correction as well. Okay. We also filed Exhibits F through C in our original set of exhibits demonstrating that each of the parties to be compulsory pooled received an election packet that included an opportunity to participate, a survey plat, and the requisite AFE and JOA. As I mentioned, testimonial Exhibit 1, as updated this morning but still out of date, well, now with the changes we made, is a complete list of parties to be pooled if you now remove Glenwood Joseph Purdy, which I will do and provide an updated exhibit to you all. Let's go through, let's turn to Exhibit DDD. Can you please describe what this exhibit shows?
Yes, this is the survey well plat that was sent with each of the notices of opportunity to participate.
And Exhibit EEE.
Yes, this is the AFE that was sent with each notice representing the estimated well costs for drilling the subject well. As Ms. Utley mentioned, several lessors claim title in various fee tracts through one or more of the estates of the deceased record mineral interest owners who appear on pages 3 through 5 of the request. I refer the board to those pages for a complete list of the estates being pooled. This cause contains a very large number of estates to be pooled. So either no Utah probate of the estates has been initiated, or if it's been filed, is incomplete in that there has been no proper distribution made to the heirs or devisees. Based on heirship affidavits and other inquiries and research done by OVINTIV's lease broker, we believe we have leased all of their successors, but without an order from a Utah court confirming their succession, the possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore OVINTIV seeks to compulsory pool their interests.
Thank you. And I would now refer the board to Exhibit F that's on file in this cause, which is the proof of publication in the Uinta Basin Standard. Can you please describe what that exhibit shows?
Yes, this is the proof of publication for the Uinta Basin Standard prepared by Ms. Utley at my direction, and confirmed that we did not receive any responses to the published notice.
Thank you. Moving on to the JOA. Exhibit GGG and HHH. Can you please describe Exhibit GGG general and explain which parties this JOA applies to?
Yes, this is the JOA that was attached to the RAA as Exhibit 1, and which will govern operations between OVINTIV as operator and the non-consenting compulsory pooled parties, who include all of the parties and estates to be compulsory pooled except for Bro and International Petroleum, as will be discussed shortly. Exhibit G is a standard industry form supplied by the AAPL, American Association of Professional Landmen. This form is 610, which is the 1989 version that has been modified to address horizontal wells. The terms and conditions contained therein, including the modifications made, are consistent with other JOAs executed by other working interest owners in this particular drilling unit and are commonly found in more recently developed horizontal well drilling units. OVINTIV has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
Thank you. And now looking at page 7 of the JOA, this is the non-consent penalty. Can you see, even to explain what appears there? Do you know well enough, having seen it so many times?
Yes, this is page 7 of the JOA describing the non-consent penalties. This particular JOA provides for a 100%, 300% non-consent penalty, which is the same as contained in the JOAs signed by the other working interest owners in this drilling unit.
And Exhibit C of the JOA is the COPUS accounting procedures. Can you describe what appears on Exhibit C to the JOA?
Yes, Exhibit C is the COPUS document outlining all the accounting procedures. Again, this is a standard industry form, almost universally utilized, similar to other JOAs in the Uinta Basin. In particular, page C3, Article 3B sets the interest rate at the prime rate published in the Wall Street Journal plus 3%, which has been deemed fair compensation and to encourage timely payment of chargeable costs and expenses.
And page C9.
This provision, C9, outlines the overhead charges, which in this case are $10,000 for the drilling rate and $1,000 for the producing rate.
In your expert opinion, are the terms and conditions of the proposed joint operating agreement fair and reasonable and consistent with those accepted by other working interest owners in this DSU and with those commonly accepted by industry, in particular in the Uinta Basin with respect to horizontal well operations?
Yes.
Now, Exhibit HHH, can you help the board understand why we provided 2 JOAs with our request for agency action and what is different about this second one?
Yes, this is the JOA that was attached to the RAA as Exhibit 2 and which is proposed to govern operations as between OVINTIV as the operator and Bro Energy and International Petroleum. As explained earlier, Bro and International Petroleum are lessees under fee leases within the drilling unit. They are consenting owners in the subject well, but have failed to execute a JOA, which would have resulted in voluntarily pooling their interests. As such, Bro and International Petroleum must be pooled solely for imposition of a JOA, and the interests of their lessors must also be compulsory pooled. Their lessors will be entitled to the royalty as provided in their respective leases. As a demonstration of good faith, OVINTIV submitted the Bro IP JOA to govern operations as between OVINTIV and Bro and IP. This particular JOA includes amendments that we have previously agreed to between the parties with respect to other drilling units.
And have you had any response from Bro or IP as to whether they have signed or will be signing that JOA?
I have not.
Okay, thank you. Utah Code Annotated Section 40-6-6.5, sub 6 and 8 provide that a compulsory pooled unleased owner is entitled to payment of the average weighted fee landowner's royalty during the payout period, which does not include federal, state, or Indian lease royalties. Turning to Exhibit III, can you please describe what this exhibit shows?
Yes, this is the average weighted royalty spreadsheet calculation for the BL1H. This reflects the calculation of the acreage weighted average royalty for sections 4 and 9 for leases taken as of the spud date of March 24th, 2018. And that calculation is 18.356514%. And this royalty this calculation does include any royalty provided in lease forms attached as an exhibit to JOAs signed by any unleased working interest owners in the drilling unit.
Thank you. As to notice, I would like to refer the board to the certificate of mailing that's on file in this cause, filed on January 16th of this year. This is a pleading prepared by Lear & Lear under Mr. Burns' direction. Can you please just describe briefly what the certificate of mailing shows?
Yes, it just shows the evidence that we mailed the RAA to all the pertinent parties. The addresses were derived from a title opinion dated May 25th, 2020, as updated by a search of the county records by Lone Wolf and our own internal records.
And Exhibit Triple M, which is a copy of the certified mailing return receipts, was also prepared by us, Lear and Lear, under your direction. And can you just describe a little more than I just did about what this shows?
Yes, this just demonstrates the receipt status of the mailings sent to each of these parties being pulled today, which mailings were sent via certified mail with return receipt requested.
Thank you, Mr. Burns. That's all I have for this witness. Is Mr. Wall available?
Division.
Oh, I'm sorry.
Yeah, I just have a couple questions, maybe just clarifications on some things. Can we go back to testimonial exhibit 1? We went through it kind of fast for me.
Okay.
Sorry, I'm a little slow.
No, you're
I just want to confirm some stuff. So we're removing Bart Wilcox
correct.
and Brett Eugene Wilcox.
Yes.
We are removing Kelly Glazier. Is that one of the parties?
Yes.
Yes, Kelly was.
Was Lloyd I. Nelson one of the parties? Okay. Natalie Davis. I don't know if we mentioned her, but I noticed she was not on there.
Yes, she was also removed.
Okay.
Natalie Davis, Lloyd I. Nelson. Kelly Glazer.
Okay. Patricia Franz.
Yep.
Okay. And the trusts. So could you just explain again? So they said they did not own an interest anymore?
That's correct. As I recall, it's been a little while, Mr. Callister, who's the administrator of all 3 trusts, contacted us and basically said one of the trusts never owned any interests, and the other 2 trusts have been fully distributed, so they don't own any interests either.
Okay.
He provided an affidavit to the same, which has been recorded, so that's
Okay.
the status of those.
And so where did their interest end up then? Was it somebody who's already leased, or like if we were just if we were taking them out, did it go somewhere?
Yes, I don't have that answer right in front of me, but it did. I don't believe it's anyone that's still remaining on the list.
Okay. All right. Just want to confirm that. And then Tim Shepard was the last name.
He was also
He's
removed.
over.
He's
Okay,
leased.
that's
Yep.
great. All right. Okay. My next clarification I just wanted to make. Exhibit EEE, that was the AFE. Are you able to bring that up at all?
Yes. I am.
So the first page is cost estimates. And let me pull up mine as well so I can see it a little bit better. Yeah, so the first page we have cost estimates. I get that, comes to $2,700,000, $800,000. Then we have another page of the AFE, which has a whole bunch of other totals. I'm just curious, so I see the $2,800,000, those other numbers, what are those? So over on the total side. So I guess what I'm really asking is, did we get a cost estimate for all of these numbers in there that was sent out to the parties?
Yeah, so Newfield at the time, we broke out our AFEs into the A, C, D, and F. A being like artificial lift production equipment,
Okay.
C being completion, D drilling, F facilities.
All right.
And so those are the final totals that total to the 6.728 million.
Okay, so so each category in there was like a different expense that they categorize, and that's how they're broken out in the FE?
Correct.
All right, thank you. Yeah, I was just trying to understand why we had just the cost estimate and then an AFE, but thank you. My next question is, as to the JOAs, JMD, their interest, are they going to be just under the non-consenting parties JOA?
Yes.
Okay, and so the other one is just for Bro and International Petroleum?
Yes.
All right. I just noticed, I mean, I don't know if this is something we probably won't correct it for the final one, but we have interested parties fractions in the JOA at the end, in Exhibit A to the JOA. The one for Bro was really low, and I just, if we're going to include both parties, just want to make sure they were correct when we submit those as a final exhibit. Does that make sense? Or if you have an explanation for that, that's great.
So are you talking about where it shows OVINTIV's interest?
Yes.
And then Bro IP?
Yeah, other interests, yep.
Okay, so I think on that particular one, we'd have to look at it, but we've split out, we totaled Bro and IP's interest, put that on its own line item, and then just, I can't remember if it was all included, if the remainder was all included in OVINTIV's interest, or if it was just OVINTIV's interest and then a separate line item for the non-consenting people.
Yeah, yeah. Yeah, so if we just clarify that Exhibit A to both those JOAs, that's just the correct interest. It's updated based on all of the changes we've made. But yeah, other than that, no further questions from the exhibit, from the division, sorry.
Ms. Utley, you may proceed.
Thank you. I am ready for Mr. Christopher Wall.
Okay. Oh, I'm sorry. Board questions?
Yeah, this 7.5% compulsory pooled is higher than the board is normally seeing. Can you give us any specifics as to why, there's some general, you brought up general things, but anything specific that's unusual about this drilling unit that's
Yeah, so the biggest piece of that is this JMD Energy. So of these 7%, roughly, they have 5.4%. So they operated that well, has since gone defunct. It was a farm out agreement with Harvest and Branta back when they got that interest. So that is a sizable interest that we typically are not pooling something of that size, but that is why it totals to the 7%.
Okay, so in the meanwhile, what happens with that 5.4%? What's the disposition of those royalties?
Well, OVINTIV, as operator of the long lateral horizontal Beal well, we pay royalties on behalf of JMD's mineral owners. So we're paying mineral owners to them under the Beal well. I can't speak for what's going on with the JMD well itself.
Can you find those you found those royalty interest owners?
Yes, they would have been included in our title opinion for this unit, sections 4 and 9.
But along with that well hasn't produced a long time. I just looked at it, and it produced a month here or there over the last 3 or 4 years, been shut in. Right now we're collecting on a bond to try to reclaim it. They turned it over to the division, a very unhappy landowner there. Why is their lease still held by production, the leases that they've took?
Well, the Beal has been on production for since 2018, so that has HBP'd those leases.
But without production, though, they can't. It depends on the language of the lease, but normally once there's not producing and paying quantities, that lease is expired. And looking out for those interest owners, if I was one, I would say, hey, that lease expired. I want a lease to OVINTIV and get a good royalty. And
Yeah, I don't know exactly when it stopped producing, but we had a title opinion prepared that prior to drilling the Beal well that validated all of the record title owners.
Back
and-
5 years ago, they probably could have argued that it was held by production, but today I don't think they can.
Well, it's held by those leases are held by the Beal well. As soon as the Beal well was drilled and put on production, it further HBP'd those leases, so to speak.
Oh, yeah, right, okay. Yeah, 5 years ago, there was enough production to, okay.
Board, do you have any further questions? Okay, I think we'll move on.
Okay. Mr. Wall, will you please state your name and address for the business? Your name and business address for the record.
Yes, Chris Wall, 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
And what is your position with OVINTIV?
I am a senior reservoir engineer over the Uinta asset.
As was noted at the beginning of this hearing, Mr. Wall has been qualified as an expert in petroleum engineering. We are going to take a look at a couple of exhibits, beginning with Exhibit Triple J. Was this exhibit prepared by you or OVINTIV personnel with your review?
Yes.
And can you describe what this exhibit shows?
This exhibit depicts the actual costs incurred in drilling and completing and operating for the subject well through December 31st, 2023. It also has, reasonable variance to the original AFE.
And in your expert opinion, were the costs fair, reasonable, and necessary?
Yes.
I'd like to remind the board that the subject well was deemed economically feasible, as that term is used in the 139-150 order to drill. Mr. Wall, what does OVINTIV believe the P&A cost estimate to be?
It's $75,000 per well. That's pretty consistent with the Uinta Basin P&A costs charged to and by OVINTIV, and that's based on the 100% working interest.
Great. Now, Exhibit Triple K. What does this show?
This is a plat of nearby existing horizontal well development at the time the Beal was spud.
Thank you. And finally, Exhibit LLL. Can you address the risks associated with drilling this well?
Yes. So some of the risks that were observed at the time of drilling, we always have capital cost expectation due to the lack of well control. Also, there's shallow hazards throughout the area with artesian water flows that's occasionally cause us to re-drill wells. The Uteland Butte formation has high clay intervals, which have the potential to collapse pipe or stick drill pipe and casing, causing re-drills in that case as well. And then also future oil price uncertainty. And then lastly, during this well, there weren't any actual operational challenges occurred while we drilled this particular well.
Okay, and based on these risks and in your expert opinion, is a 300% risk compensation award justified?
Yes.
And can you give us a little explanation why?
Sure. So the risk penalty is justified because we're able to, I'll say this, the risks exists in the well when we drill it back in 2018. Those haven't gone away. Future oil price uncertainty still exists. And this is a fair compensation that we do agree to with JOAs.
Thank you. That's all I have for this witness. If there are any questions.
Division?
Yeah, I just have a question for Mr. Wall. The notice that were sent out to the parties, correctly indicated an AFE cost and also had additional operating costs since there was a rather large gap there. I just would like, if you could explain operating expenses that were indicated were about $2,484,000. But Exhibit JJJ doesn't seem to be the same number. I'm just curious, why would there be a discrepancy between what we were telling these parties, here's the operating costs as of July 2023, and here are actual operating costs?
So are you referring to the AFE that goes out with the notice?
Yeah, well, not the feed, the letters that were sent out to all of the parties. They all had two numbers. They had the AFE amount and then additional operating costs. I don't know if you have one of those in front of you.
I don't, and that, that might be a better question for Mr. Burns.
Would you have an answer to that discrepancy, Mr. Burns?
The only thing would be that this was pulled, we sent these letters out early or the early part of 2023, so there just may have been some accounting adjustments that changed up until the December 31st date when the numbers were pulled. Otherwise, I don't have a specific answer as to why they're slightly different.
Okay. Yeah, so there's the number there. I just, from our standpoint, I'm just looking at, this is what we told the parties, this is what you would also be responsible for. And then we have an exhibit that actually has costs, and those are different. And so I was hoping that you guys had an explanation there, but I don't know all about the accounting background, and I'm not presuming you to either, but thank you for trying to answer that question. Other than that, we have no further questions.
Thank you. Or do you have questions, Mr. Galecki?
Yeah, I just want to quickly ask on Exhibit KKK, does that actually represent the various wells that have been drilled in the area?
So that represents only the wells that were drilled at the time the Beal well was spud. So there could be additional wells drilled after this Beal well.
And so that's representative of 2018 drilling?
Correct.
Okay, thank you.
Do you have any other questions?
Yeah, just question on the risks at the time of drilling. Given our discussion at the previous hearing, future oil prices, maybe it's a question for Ginger. Can we consider future oil prices in the risk compensation award?
My answer is yes. You have in numerous prior causes. There's nothing that prohibits you from doing that, so yes.
Any thoughts from the division on that? Or?
Yeah, I guess piggybacking on discussion that happened earlier today, our current rule says that you may consider, and we have a laundry list of things. If we're not given any guidance that we're limited beyond that or what we can add to that. So I and the division would appear to agree with Mrs. Utley.
Is there currently a well producing in this spacing unit?
Just that old one.
That old one is the only well in that spacing
It's
unit?
not producing.
And it's not producing. Thank you.
Well, the Beal well, the Beal 1H that we're force pooling today is producing.
Is producing today?
Yes.
Okay, that's what I needed. Any other questions? Board, do you have a summation?
I do. I would like to move for admission of exhibits A through H, J through MM, OO through QQ, UU through YY, AAA through triple M, and testimonial exhibit number 1. And I will be providing a revised testimonial exhibit number 1 and a revised exhibit E. In conclusion, as the evidence and testimony have established, all statutory and regulatory requirements have been satisfied for approving this request. All interested parties have been provided full legal notice of the request and instant proceedings, and none have objected. The division has expressed support for granting this request, and OVINTIV respectfully requests the board enter an order granting the request as pled.
Okay?
Oh, I'm sorry. I think I moved fast before
We
I let
will-
you actually.
We will accept those
Thank you.
as revised for filing. Are there any objections to the exhibits?
There's no objections.
Thank you. All right. Board, do we need to deliberate on this before we make a motion? Let's take 10 minutes to deliberate. We'll come back at 2:10. We'll try to be sure everyone gets out of here by 3:30. Okay. We are back on the record. And I think we're ready for a motion.
Okay.
I move that the board approve the request for agency action.
A second.
It's been moved and seconded. Can I get a vote, please? All in favor?
Aye.
Any opposed? Mr. Moon, you participated, is that correct? That's a unanimous board decision. Thank you. Would you please, Ms. Utley, prepare the order? Thank you.
Thank you.
Thank you.
Three 3:30 is what they said at the very latest. Mr. Mayo, would you tell me when you're ready? Well.
Ms. Garrison, we're ready. We've got our first witness is appearing remotely, so just as long as there's a mic check that he's ready and available, we should be ready.
Okay, we'll see if we can do that.
Nope.
Looks
Kevin
good.
Anderson, can you hear me?
Good check. Yeah.
Good, okay. Next issue is docket number 2024-006, cause number 130-29. In the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Co., LLC, for an order amending the board's orders in cause number 139-138 and 600-04 to reduce heel toe setbacks from 330 feet to 100 feet for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations in sections 28 to 33, 2 South, 1 West, USM, Duchesne County, Utah. Appearance of counsel.
Thank you, Madam Chair. Mitch Mayo of Lear & Lear PLLC on behalf of the petitioners, XCL Resources and XCL Asset Co.
Thank you. Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
All right. Anybody need swearing in? Are we?
My witnesses do need swearing in. Madam Chair, members of the board, again, Mitch Mayo, collectively on behalf of the petitioners here. With me in person today is Mr. Josh Sigler and Mr. Mark Gravy. Mr. Gravy was subject of a motion to appear electronically on the possibility that he may have to be appearing electronically. He clearly is not. However, we did file a motion to have Mr. Annenson appear electronically, and he has been here and is there. Thank you, Mr. Annenson. I have my cell phone on because Mr. Annenson is remote, so please forgive me if it beeps. And now would be probably an appropriate time to have the witness sworn in.
Thank you.
Okay. Raise your hand, please. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
You do, thank you.
Thank you.
Thank you. I may go quickly in this as well. Please slow me down. I've got witnesses who are trying to get to a flight as well. So if there are questions, just jump in. And the resumes of Mr. Annenson, Sigler, and Gravy were submitted as Exhibit A in this cause. If asked, they each would confirm their resumes as true and correct. Each has appeared as and been recognized as an expert witness in prior causes before this board. Mr. Annenson will be testifying solely as a fact witness today, nonetheless, but I'd like to ask if the division has any objection to recognizing Mr. Sigler and Gravy as experts in their respective fields, Mr. Sigler for geoscience and geology, and Mr. Gravy for reservoir engineering and development.
No objections by the division.
Board? So accepted.
Thank you. Also, with permission and keeping with past practice, I will move for admission of exhibits at the close of my case in chief.
Thank you.
Quick background. XCL is before you today to request something that is by now a fairly straightforward matter, the reduction of heel-toe setbacks. As the board is aware, the reduction of heel-toe setbacks has become fairly standard practice over the past few years as operator after operator has compiled sufficient data to determine that it's appropriate to reduce setbacks within their acreage. Also, as the board has continued to grant those, there's a need to offset any competitive advantage, if any, from offsetting operators. After extensive horizontal drilling, XCL has now compiled that data and is here to present it to you today to demonstrate that the reduction of heel-toe setbacks to 100 feet for the wells drilled on the subject lands will increase productivity, prevent waste, and adequately protect correlative rights. In fact, I'd like to note for the board that this relief is similar and consistent to and consistent with relief granted in prior causes last year, 130-21, which was a heel-toe setback reduction that the board granted for XCL in section 2 South 3 West and 2 South 2 West, the neighboring ranges, and in cause number 130-16, which was entered last February on behalf of OVINTIV to reduce the heel-toe setbacks in the adjoining DSU. The board has jurisdiction over this cause pursuant to Utah Code annotated 40-6-5 and 40-6-6. Notice was provided as required under Utah law to all interested parties and to all relevant governmental agencies. Each of these mailings was sent either to the address provided by the government agency or to the last known address of record as disclosed by the county recorder's office records or as supplemented by XCL's internal records. In addition, notice was published in this matter in the Deseret News on February 2nd, the Salt Lake Tribune on February 4th, and the Uinta Basin Standard on the 7th of February. No one filed a protest or objection to the requested issue in this case. However, the division did file a notice of non-opposition on February 12th in this cause, noted therein that, quote, the division does not oppose, end quote, the request, that the request today, quote, is similar to other relief granted in the area, end quote, and that, quote, the board should grant petitioner's request, end quote, if sufficient supporting evidence presented today. We believe that such evidence will be presented. Finally, it's worth noting that XCL notified all offset operators and none expressed opposition to the request here today. With that, I will begin my examination of Mr. Annenson. Mr. Annenson, can you hear me okay?
I can.
Okay, will you begin by stating your name and business address for the record?
Kevin Annenson, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay, and what is your current position with XCL?
Vice President of Business Development and Land.
Okay, and in that role, do you have responsibility over the lands at issue here today?
Yes.
Okay. Can you please, as a beginning matter, provide corporate and bonding status for XCL for the record?
XCL is a Texas corporation in good standings, having its principal place of business located here in Houston, Texas. We are fully bonded with all relevant business, Indian, and state Utah agencies.
Thank you. And can you please briefly explain the relationship between the two petitioners here today, XCL Asset Co. and XCL Resources for the record?
Resources is where the employees are held. Asset Co. operates with a management services agreement such that Resources manages the assets for Asset Co.
Okay, so sister entities with a contractual agreement between them.
That's correct.
Okay, thank you. I'd like to remind the board that Mr. Annenson, although an expert in general land, it will be testifying as a fact witness here today. And with that, I'm going to turn you to what's been submitted as Exhibit C, D, and E. Do you recognize these exhibits?
I do.
And they may be shown on your screen if you need them as well. I'm not sure.
Yeah. Make it a little bit bigger.
Were these prepared by you or under your direction or supervision?
Yes.
Okay. Exhibit C, can you please help orient the board as to where the lands that we're here discussing today are located?
These lands are located there in the southwest quarter of Township 2 South, Range 1 West. As you can see, not too far there from the town of Roosevelt. And then you can see the town of Duchesne County there about onto the southeast there.
Okay.
Pretty close to the Duchesne County, Uinta County border.
Okay, perfect. Excuse me. Now turning to Exhibit D. Can you please tell the board what this shows?
Sure. So it shows the lands that are filled in green that are subject to this request, which is spaced pursuant to Order 139-138. Excuse me. Order 139-138 establishes 3 1280 DSUs at issue, stand-up units with current production setbacks of 560 feet, laterally east and west, and 330 heel-toe north and south.
Okay. Does it, I guess, I mentioned earlier in my introduction, the offsetting orders that were approved. And let me go back to here. The lands we're here discussing today are 2 south, 1 west. Those offset orders, can you tell what lands those cover for the board? And
Sure. So just to the west, abutting our 2 south, 1 west, 30 and 31, you'll notice there, or on 2-2, 25 and 36, those lands were subject to an order of 130-16, which was one of the offset orders, which granted a 100-foot heel-toe production setback for OVINTIV as they operate that DSU, and it extends up into XCL's position.
Okay.
And that order 130-16 was entered about a year ago, February of 23.
Okay. Thank you. And just to be clear, with the 1280s that you're here discussing, you mentioned production setbacks of 560 feet laterally and 330-foot heel-toe. The only change that XCL is looking to effect today is the reduction of the heel-toe setbacks. Is that right?
That's correct.
Okay. Can you please talk about notice of the requests using this exhibit or any other, and just assure the board, kind of walk them through who you noticed and why and how you got those names?
Sure. So we go through and we noticed, all interested parties, not only within our units, but also, as you mentioned in your opening statement, all offset owners. So we do that through the work of title opinions, which are prepared by title attorneys. And then all of those are ran forward through the county records to ensure that we have located all updated owners, just in the instance that perhaps ownership may have changed between rendering of a title opinion to current.
Okay. As for ownerships, how is it owned? Is it a mix of fee? Is it all fee? Is there some state, federal? Just kind of a brief summary.
Yeah, so we notice all private, state, federal, and tribal interests.
Okay. And ownership on these 6 sections of land, is it fair to say it's mixed? There's a little tribal, a little federal, a little state, a little fee, or are these all fee in your?
It's a mix of all.
Okay. Thank you. Did you receive any responses from any of these mailings?
We did not, no.
Okay. Now turning to Exhibit E, can you please show the board tell the board what this exhibit shows?
Excuse me. So this shows the 2 overlapping 2560 DSUs that were established by the board in cause number 600-04. Identified in 600-04 order as number 3 and number 4. Unit number 3 would be comprised of sections 28, 29, 32, and 33, and then unit.
So that would be outlined in the solid red line on the screen. Is that right?
Yes, that's correct.
Okay.
And then outlined in the dash, the red dash would be your 29, 30, 31, and 32, all located in 2 south, 1 west.
Okay. And the production setbacks on the 2560 units that were established under the 600-04, are they the same, similar to the setbacks on the 1280s?
Yes.
Can you discuss that?
That's correct. So identical to those 1280 DSUs at issue, the heel-toe setbacks are at 330. But to minimize the waste, there are no lateral setbacks. So the board determined that the wells were drilled within that 560 section line between the 2 adjoining 1280s is payable on a 2560 allocation.
Okay, so the heel-toe setback, the relevant setback for this hearing is the same in both the 600-04 order and the 139-138 order. They're both currently at 330 feet. Is that right?
That's correct for what we're going to today. Yes.
Okay. And XCL is seeking to have both those modified, the 604 setback and the 139-138 setback.
Right.
Okay. Mr. Ananson, in consideration of Exhibits C, D, and E, do you believe that the request under consideration today is the best plan to protect correlative rights, maximize resource recovery, and prevent waste?
That is correct.
Okay. With that, I have no further questions for Mr. Ananson and can move on to Mr. Sigler.
Division, do you have questions?
Yeah, just a clarification. Mr. Anderson, we mentioned that offset operators were noticed. I'm just curious if you have in front of you, who are the offset operators to the north and to the south of these units?
Absolutely. So to the north of us, we have one unit is Altamont, one unit is UAX, and another unit is actually XCL ourselves. So, and then to the south of us would be OVINTIV.
Okay, and all these parties were noticed as part of this request?
Absolutely.
All right, thank you. No further questions.
Board, do you have any questions for this witness? Seeing none, let's move on.
Thank you, Madam Chair. Mr. Sigler, will you please raise your right hand so we know which one of you it is? Thank you. Mr. Sigler, will you please state your name and business address for the record?
Absolutely. My name is Josh Sigler. I'm the Vice President of Geology at XCL Resources, and my business address is 600 North Shepherd Drive, Suite 390 in Houston, Texas, 77007.
Okay. Do you have a question? No, sorry. And will you please, as the VP of Geology and Geosciences, I'm assuming you have some area of responsibility over the lands at issue here today?
Absolutely. My role includes making sure that the geologic characterization of all assets that we operate, including those here on the subject lands, is complete and accurate.
Perfect. Thank you for that. Based on earlier stipulations, I'd like to remind the board that Mr. Sigler will be testifying as an expert in geosciences. I'm going to turn you, Mr. Sigler, to exhibits, what's been filed as exhibits F, G, and let's just start with F and G. Do you recognize those two exhibits?
I do. Those were prepared by my team under my direction.
Perfect. Exhibit F, type log. The board has seen plenty of these. Will you tell them what this one demonstrates relative to the request?
Absolutely. This is a type log from the Emerald Phoenix well, Emerald Phoenix 15-31-2-1W, API number of the 10-digit variety, 43013-51290, that is located in the southwest quarter of the southeast quarter of Section 31 in Section 2 South 1 West on the subject lands.
So is this the location roughly?
Absolutely, sir.
Okay, thank you.
And then furthermore, the log is comprised of a bottom track, which is a gamma ray track, which we use to identify changes in lithology within the rock, and an upper track of a deep reading resistivity log, which we use to identify changes in fluids within the rocks. This log, from left to right, starts at the top in the Uinta Formation and works down through the Upper Green River Formation into the Lower Green River and down into the Wasatch, with the primary targets for our drilling being located within the Lower Green River, our horizontal drilling within the Lower Green River and the Wasatch formations.
Okay. So would you say primary targets then would be what's denoted here in those lines?
Yes, our primary targets are broadly within all these, certainly our primary targets. We have 4 primary targets that fall within the Lower Green River down into the Wasatch. Then we have around 8 additional targets that we drill in various, they're kind of in various states of testing that are within generally within this log. We'll be testing one that does fall off of this log later this summer.
So well outside of what people are used to drilling in the basin?
Absolutely.
Okay. And I guess, do you want to discuss any of that in detail, or is it relevant to this?
Let's move to Exhibit G, because I think that might be the easiest place to take a look at it.
Perfect.
As you mentioned, our primary target within the basin for nearly all operators is the Uteland Butte that's identified here on this stratigraphic cross-section, moving from letter A in the west, which is actually on the subject lands for, I believe that was one of our previous applications, 130-6.
The 130-21 offset order. That A is in that.
Yeah, thank you. So you can see that this entire section has great continuity from that order onto the subject lands for the current order. But primary drilling targets are there in the Uteland Butte, and then several targets just below in the Wasatch, a couple more just above that Uteland Butte marker that fall below what would be the carbonate marker. We are doing extensive testing on the intervals between the Douglas Creek and that carbonate marker. Those are some new wells that we'll be drilling. And then we are testing some deeper intervals within the Wasatch all the way down into the Flagstaff that we see the tremendous resource potential that we have here, but also in some of these situations, some of these we obviously all know how prolific the Uteland Butte wells are. Not all targets are quite as prolific as those, and so one of the reasons we are here before you today is to help the economics of those wells while also recovering, making sure we're maximizing recovery along those laterals.
That makes sense. So is it fair to say that you don't anticipate these other intervals to be necessarily as prolific as the Uteland Butte, but still potentially economic given the right circumstances?
We certainly hope so, they will be as economic, but we are also realize that might mean that we need to pull a few different levers in terms of whether that's changing setbacks a little bit in this situation, or just trying to think about different ways of drilling, different techniques that might help us to increase the economic potential of those intervals as we continue testing.
Thank you. That's very helpful. I'd like to turn you one more set of exhibits for you, if I can. And these are what have been filed. We're going to skip Exhibit G, but what have been filed, Exhibit H. We're going to move to what's been filed as supplemental Exhibits I and J. Do you recognize those two exhibits?
I do. These two exhibits were also prepared by my team under my direction.
Perfect. And for supplemental Exhibit I, again, the board has seen something like this numerous times. Can you quickly tell them what about that is important for
Absolutely.
this decision?
In the top left, there is a map of our asset, including the subject lands highlighted there, and I think that we'd call that a light red.
I'd call
maybe
it
light orange.
Salmon? Sure.
Yeah. But also on there are a series of circles with arrows in them. Those arrows indicate the orientation of the maximum horizontal stress as recorded by a number of different methods, either from our own proprietary logs or from public data sources. And as you can see in those circles, you can see the stress orientation changing from something that looks a little bit more north-south over in 2 south, 3 west, over into 2 south, 2 west, and 2 south, 1 west, where they become more east-west oriented. This is indicative of the kind of the broadly noted stress swing that we see here in the Uinta Basin, and the rationale as to why we have laydown units in 2 south, 3 west, and some of the western portions of horizontal development of the Uinta Basin, and then move to stand-up units on the eastern side, as we are looking at here in 2 south, 1 west. In the bottom left is actually a well that is just offset in 2 south, 2 west, section 35. It very, very nicely depicts generally what the stress orientation is anticipated to be across the entirety of the subject lands, where the maximum stress orientation is oriented about 6 degrees off of directly east-west.
Okay, and so is that the stress orientation that XCL believes applies to the drilling units here today then?
Absolutely.
Okay. And moving on, using that information, if you could discuss Exhibit J, or supplemental Exhibit J, if I could.
Yeah, absolutely. And so supplemental Exhibit J then utilizes a little bit of information that Mr. Gravy will talk about in a few minutes, but with a drainage radius of about 165 feet that we anticipate for these wells at 10 years. When we look at that inclined drainage ellipsoid, then we would see that drainage would go about 96 feet into the setback, meaning that all of our drainage would still be on unit, not moving off unit.
Even at 10 years, that's your estimate?
Even at 10 years, even less so at something like 3 or 5 years.
Okay, thank you. Is there, in consideration of what you've testified to, Exhibits F, G, and supplemental Exhibits I and J, in your expert opinion, do you believe this request is the appropriate approach for these units and protects correlative rights while preventing waste and maximizing recovery?
Yes, I do.
Thank you. With that, I have no further questions for Mr. Sigler.
Division, do you have questions?
No questions, just a quick comment. We're thankful to XCL for updating these supplemental exhibits. When we initially reviewed the request, we had some confusion over how we felt about it, but thanks to your updating, we appreciate it.
Absolutely. Or do you have questions, Mr. Church?
Yes, Mr. Siegler, you mentioned that you will be going for deeper targets, Wasatch to even Flagstaff.
Yes, sir. We've done extensive scientific work on cores that are actually housed here at the Utah Core Research Center, as well as cuttings we've collected, drilling deep. We've drilled a deep vertical well actually down into the Flagstaff last year. We did a lot of science on that well to understand where the production in that vertical well is coming from. And as such, we've found some targets that we believe are prolific enough to go ahead and test them horizontally.
But you're asking for setbacks for 100 feet for all of these formations. You gave the caveat that you may be coming back to adjust those.
More of, I think, less about adjusting the, I think these, we would just say that the setbacks would be set the same for all of these. I think as we think about other intervals, I think some of the things we're alluding to is the potential to be looking at other methods that, of increasing the economic potential of wells. I don't know if I'm allowed to really speak to those here about future orders. Is that? Oh, well, I didn't, I just want to make sure my. Oh, yeah. We have seen other operators drilling 3-mile laterals. That is something we are strongly thinking about in some of these other intervals where they're wildly prolific intervals, but the more we can reduce that fixed cost, obviously let Mr. Gravy speak much more to the economics of things, but the more we can reduce that fixed cost of drilling fewer vertical holes and capturing more resource with a longer lateral, it's better for the economics, it's better for the surface landowners. We believe we'll be looking at some of those things just to help make some of these other intervals even more economic.
Thank you.
Mr. Moon?
So speaking as a mineral owner, I appreciate XCL's enthusiasm. I hear good things about you guys out there in the basin. Regrettably, my family has no mineral interest in your operating area. So I'm jealous of my friends that have XCL.
But on the bright side, you get a vote in all their matters.
Yeah. You get to see us here at least.
Yeah. So just a couple questions. Why is that stress transition geologically? Why did that happen? Why does it come down and then we've learned now that it turns really sharp? It used to be kind of a gradual, now it's more sharp.
And I think overarchingly the way I view it is you're looking at two different broad stress regimes. You're looking at one that's dominated by stresses within the earth that are dominated by generally the block of rock that's connected to the Uinta Mountains, particularly as you're further east. And then as you move further west, you have the Wasatch Front. You have those rocks that were, during the Cretaceous, pushed greatly to the east and thrust this direction. That ultimately is the influence of the Wasatch is truly, I believe, what's causing that change. And so when you think about it as more of two distinct stress regimes, then it starts to make, I think, a lot more sense that it's a pretty sharp transition. You're not just watching something where, well, you kind of have a far field effect and they can kind of merge together. You're really seeing two different distinct regimes.
Couple follow-up questions with that. So do you notice production? I know the further north you are, the higher your pressure, but in that same area, do you notice how much reduced production do you have when you're drilled right in that, when it's a 45?
It's a great question. I very honestly would defer to Mr. Gravy on that.
We haven't observed any.
Really?
Yeah.
And that's not testimony because he's not yet approved. That's just his opinion.
Yeah. Well, that's what I'm interested in.
There hasn't been any.
But we have also seen case studies from further south where operators have taken and looked at, well, a well that's oriented east-west, or maybe realistically more north-south, where it should have been oriented east-west, two wells of a very similar vintage with a very similar completion design. There's a substantial difference in the production of those wells.
But you're not seeing that.
We're not seeing that.
And we broadly think our field is laid out correctly.
Yeah, exactly.
So there aren't any that are drilled
Got it right the first
completely counter to what the science would say to do now.
So while I'm not an expert in production, I can say the numbers that we see from, say, looking at the wells in 2 South, 3 West, relative to the wells that are lay down versus wells that we see in an equivalent formation with an equivalent completion in 2 South, 2 West, they're broadly the exact same well on production trends, which gives us good confidence that the way we've oriented these units is proper.
Okay, and even in that transition zone, you've got to decide, and it's 50-50.
Yeah.
You kind of go either way, and your
Yeah.
production is similar to the ones east and west.
And there, what I think the industry has really found is you're really at no detriment as long as you're kind of broadly not parallel, you're not drilling wells that are parallel to the orientation of maximum horizontal stress. So where we would really see a detriment is in 2 south, 3 west, if we were drilling north-south.
Right.
Where it's 45 degrees, the fracture's traveling away from the wellbore, and you're getting drainage away from the wellbore. Whereas if your wellbore and your stress is the same, well, your hydraulic stimulation is just going the same direction as your wellbore. You start to lose the real benefits of the hydraulic stimulation.
Okay, so you don't frack those any different when it's in a transition
We
zone?
do not.
You can't aim your...
We would love to, yeah.
Can't ask it to go anyway.
Yeah.
Do we have any other questions?
Yeah, I do. Okay.
Mr. Walker?
Can we go back to the cross-section on, and my
Absolutely.
question, that one right there, yeah, very good. What do you, I can't read the scale there, but what do you estimate your formation thickness is on a Uteland Butte here?
About 125 feet, 100 it kind of ranges in thickness, anywhere from 125 to 175 feet of thickness, kind of generally throughout the deepest portions of the basin.
Okay, so in this area that you're talking about here, we're 150 feet or
That's
something
right.
like that. Okay, so, and now you've got an estimate on your half-length of your frac growth. Do you have any estimate on the height
Yeah.
of your frac growth?
Well, so we actually...
I'm
yeah.
concerned, are you going to grow out of zone, or are you going to be stay in zone?
Well, we broadly stay in zone. One thing we do is we do a lot of geochemical tracer work, or really we do a lot of geochemical analyses of the fluids that are in the rock, as well as the fluids that come out of the borehole. So we compare, we actually take like 30-foot samples, send them to a lab that does very detailed characterization of that oil, and they can tell us what components are within the oil, and it changes with depth. Broadly, there's a really beautiful maturity trend. We can see from shallow, the oil is less mature, more of a black wax, to something that's more mature and more yellow in color, or yellow waxes as you go deeper. That's all a result of many different compounds cracking as the hydrocarbons mature. So as we get deeper, we can then see when we produce from a wellbore, we can see the changes in that oil from shallow to deep. And so broadly, let's take like the Uteland Butte, for example. We might see about, if the interval is about 150 feet thick, we probably see somewhere on the order of like 175 foot of geochemical drainage. But we are exceptionally careful not to stack wellbores in adjacent zones right on top of each other, because we know this is a phenomenon. So what we've really kind of done is done a really, I believe, a really thorough job of trying to find a excellent blend of looking for good drainage width and then staggering our wellbores such that we get just enough height growth that those drainage ellipsoids really fit together nicely and maximize the recovery we're seeing from the rock.
Okay, so
Currently, we need to drill a target that's about 150 feet deeper than the Uteland Butte. And so if we truly believed it would be, the one drainage system, we wouldn't drill that well. And so if you go through our permitting, we drill the well in the Uteland Butte, and then 150 feet deeper, we have a separate development. And that's Josh's point, that you notice different changes in the oil quality between those two wells.
Mr. Mayo, how many more witnesses are you going to have?
Mr. Green is my last one.
Quick question. I don't want to make you miss your plane. But so in that Uteland Butte, what's the most wells you've been able to get in a 5280?
5?
I think that would be correct. The one thing I'll say is, one thing we are, again, very careful to do, we don't want to overspace that. We don't want to invest too much money to get the same amount of oil out. So the Uteland Butte it's probably 5, but then if you really look at, say, the Uteland Butte, and just below the Wasatch, particularly on our acreage, we have another lacustrine cycle that, if you could really look at that log character, it's like the 150 feet right below that pink marker is pretty much identical to the Uteland Butte. We call it the Wasatch 5 Upper, and so we wine rack that very carefully, and I think we've gotten as to the equivalent spacing of what would be 8 wells per section, certainly 7, but I think if you looked at some equivalent spacing, we've gotten to 8 wells per section in those 2 benches together. Okay. And that's where, to be very frank, those are the two, that portion of rock in the basin is really where you have probably the most prolific source rocks, and that's where that's the engine that drives the basin.
I'm happy to. Yeah, thank you for that. Mr. Gravy, will you please state your name? You can steal that microphone from.
Sure.
Your name and business address for the record.
Mark Gravy. I work at 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007, and my title is Executive Vice President of Reservoir and Development.
Okay, and I'm assuming you have a supervisory role over these lands at issue here today in that capacity?
I do, and these exhibits were prepared under my direction.
Okay, well, let's do that. Based on earlier stipulation, I'd like to remind the board that Mr. Gravy's testifying as an expert here. You mentioned what's been submitted as supplemental exhibit H and exhibit K were each prepared by you or under your direction or supervision. Exhibit H.
Yes, they were.
Please walk the board through this, if you would.
Sure. So the right side of the page is an example from the division staff memorandum, and it is a example of how to use the Hale and Evers calculation to determine the drainage radii of an ellipse. And on the left side is the same variables in yellow that produce the results in red, so following the same practice that was in the memorandum, we went through with the data we have on our wells to generate those results. And then above that, a couple of bullet points. We took the Hale and Evers results and we compared it to kind of a proprietary software computer program where it's maybe a little more robust or at least just different, and realized the very similar result. And then the other point to note is the minor ellipse. So when you look at the smaller drainage area, on the bottom of that diagram, that's probably best approximated by cluster spacing. So as you're moving along a lateral, you'll put a hole in the well to try to create a fracture at that point, and every group of holes is called a cluster. And so as you move from one cluster to the next, the question becomes, how far apart should those be, because everyone costs money to go through that process. And so this says, the drainage over 10 years is 94 feet, but we currently invest in the wellbores to produce those fractures roughly every 20 feet.
Okay. Thank you for that. Exhibit, so just to clarify, the information on the right is just from the division's memo, has no application to the lands here.
That's correct. It's just used as a reference to what we're doing on the left-hand side.
Perfect. And the last exhibit that I think we're here to discuss today, the economics. Obviously, the board's facing a decision today whether to decrease the heel-toe setbacks from 330 to 100. Will you tell them why that's an economically good decision?
Yeah, we think a couple of points. One, protecting correlative rights means not wasting resource. It means trying to have a lower, break even so that it sustains development in the basin. And so when OVINTIV noticed us south of us, we didn't oppose their position and they didn't oppose ours, because we don't believe that it threatened the economics of our projects or that this threatens theirs. And ultimately that this leads to higher, recovered revenues, both for royalty owners. So, for an example, a 940 MBO well, the total royalty revenue at 18% is $9 million, but with a longer lateral, it's $9.4 million. And the taxes just above it go from 3.56 to 3.74. So across a 12-well unit, which is roughly how we develop the formations between the bottom of the Green River and the top of the Wasatch, that increases the total taxes from $42.7 million to $44.9 million. It increases the total royalty revenue from 108 to 112.8. And it also just increases the likelihood that these projects remain economic and viable through commodity cycles.
Okay. With that, I don't have any follow-up on that except to ask you about your expert opinion. Do you believe, based on the exhibits you've discussed in the presentation today, that the request here is both just and reasonable, but also protects correlative rights and maximizes resource recovery and prevents waste?
I do.
Okay. With that, I have no further questions for the witnesses, and our presentation is complete, and I yield to the division.
Thank you. We have no questions for Mr. Gravy, and the division, we reviewed this request. As I mentioned earlier, we did have some questions, but they have been answered, and based on the testimony today, the division is supportive of this request.
Thank you. Board, do you have any questions? I think we're good. Do you have a sum and?
I would really like you to approve this request.
So noted.
Thank you. I can elaborate, but I think we're good with that.
I did have one question.
One question from the board here.
Can we go back to the last exhibit?
Sure.
On that, you've, oh, must be the one before that. The one with L sub F at equals 200 feet.
This one. Yeah.
Okay, what's the difference between that 200 feet and the your half length you're computing there of the frac?
Sorry, I'm not sure where you're pointing.
Example of division staff memorandum, you've got,
I think this is the number you're looking for, Mr. Walker. It's in this bottom, and I could be wrong, Mark. Tell me if
Yeah,
I'm-
so the
AF.
That's right. AF, that means that there is some drainage just beyond the frac length.
okay.
So
And
over
actually,
time, it actually extends beyond that frac length.
Okay. And actually, I was asking about the one, if you go over further, Mitch, up right there, there's 200 feet, right?
On this right side?
Yeah.
This is all taken from an example the division provided, so this has no application, and I'm sorry for the confusion.
Thank you. That's all. Okay, thank you.
Anything to sum before we do exhibits?
I should move for admission of exhibits. Yes, I should move for exhibits. Exhibits, I'd like to move for admission of exhibits A through G and K, as well as supplemental exhibits H, I, and J.
And K?
That's correct, yep.
Admitted.
Thank you.
Let's see, board. Do we need to discuss? Are we ready to proceed on this matter?
I would move that we approve this request for agency action.
Second.
It's been moved and seconded. Can I get a vote? All in favor?
Aye.
Any opposed? Hearing none, it's unanimously approved. Mr. Mayo, would you please prepare the order?
I'd be happy to, and thank you for accommodating the schedules. These guys will be so excited to get home.
Thank you.
I don't know, a night in Salt Lake City, can't beat it.
With that, there's,
I think we can adjourn. Oh, yeah. Somebody move to adjourn?
I'll make a motion to adjourn.
Second.
We are adjourned,
thank you.
and we are off the record.